available, Lordship. Kindly fix the matter after a week, Your Honor.
Yes,
Okay, bye.
May I plead your lordship? Lordship, item number 11. My lord, LCR received, my lord.
On the prayer of Lanai Council.
Madam, may be fixed for hearing. my
Item
lord.
number
11 and 17, my lord.
11, 7, what do you want?
Matter may be fixed for hearing, my lord.
Oh,
Earlier entry may continue.
let the matter come up, you want to go. You want to go home early today, mention and go. You wait for your turn, madam. It is in the list. Unless it is for adjournment. You want to go home early today? You want to go home early today? Oh. I see. Huh? Oh, otherwise, you will be delayed by half an hour, na? Precious half an hour time. Okay, madam, you go.
Your Lordship, I beg to mention item number 23 of supplementary list. Your Lordship, my senior counsel is suffering from fever, so kindly adjourn this matter and list it after 2 weeks.
On the prayer, Mr.
Vijay Das.
Matter after 2 weeks. Yes, next.
May I please, your lordship? Lordship, I beg to mention item number 19. My senior is out of station. Kindly list on 7+6.
Okay, on the prayer, Mr.
A. Goswami.
You have informed the other side.
Yes.
This is about this recruitment, I suppose. Why you are dragging it? This is about some recruitment.
I have to see, lordship.
No, not for this is not yours, not yours. These are not of foreigners. These are recruitment. High Court. Item number 21. 19. 2021. This is High Court matter. Service matter.
Oh, yes.
Service matter. Need to key what is this? On the prayer, Mr. Earlier Miss E. Nath. What is your name now? Today is a different case.
A. Goswami.
J. Roy, Boro, assisting terms of Jonathan. In terms of past so and so, the following person, namely so and so, are implemented. Since notice have been already issued that the private person permitted to take steps. Have you taken steps?
Yes, lordship. Yes, lordship.
In received as person, not having duly served on 22. When you take the steps, you have taken steps on.
No, only October that earlier large one.
Notice that this in terms of the so names of so are struck off from a party, are implemented party responsibility notice have been 3 days. You have not taken steps. You say yes. Case Lojima 2610 notice was issued to respond to by the staff. However, respondent number. In respect to the newly implemented, the notice was issued by the staff, but neither ID card. Okay. Okay, await service report in respect of the newly implemented respondents number 37 to 43. This after 2 weeks, huh? You said 2 weeks?
Yeah.
Just a minute. Oh, okay. Oh, that's me.
It was 21.
Office note dated. Office note. Lojima order dated 27/10/2022 indicates that notice have been served delivered to respondent numbers 37 to 43. The new one. Further, postal concern for the case. However, we grant some more time to the respondents to appear to this course, this after 2 weeks, yes.
Check.
Daily list for admission, item number 2.
Makshar Ali. Yes, what is this today for? What?
LCR received ballot.
Okay, Sindhar reservation. Next,
Published.
next,
Yes, Lord.
Ram Sagar,
Item number 3.
LCR received lordship, maybe fixed.
Sindhar records.
Early entry may be continued.
Hearing, huh? Early
Early
entry order will continue. Yes, next,
Highly applied.
Torun Mandal,
4.
Elsa receive, yes, same, same order, same order, same order.
Item number 5.
Pushpa, Sindhar records have been estimated list for hearing. Yes, next,
Item number 6.
Cypher. Yes, same order. Sindhar records have been received the medical list for hearing. Yes, next,
Item 7.
Kurban. Same order, yes. Our interim order will continue. Yes,
Item number 8.
Bonisha. Same order. Anwar.
Item number 9.
Same order. In records,
10.
10. Same order.
11 adjourned. Item 12.
12. Same order.
Lordship,
Yes,
Lordship,
12.
can you produce last order, Lordship?
Item number 12.
Lordship.
12.
Yes.
Item number 12.
Lordship. Lordship, order dated.
Khadija.
18/3.
18-3. Hard notice till the next. Considered. Okay. After the submission petition started from the revenue authority, the village has submitted by 102 village. Have you got?
No, Lordship. Lordship, in pursuance of this order, Lordship, the petitioner went to the revenue circle officer to obtain the certificate, Lordship, but no such certificate was issued, Lordship.
Okay, you list after 3 weeks.
3 weeks, Lordship.
3 weeks to enable the petitioner to obtain the certificate as directed earlier on 18-3. In the meantime, earlier interim order will continue.
Yes, Lordship.
Yes, next.
Item number 13.
Abdul. Records have been received for hearing? Yes, same order.
Item number 14.
Noor.
My lord.
Same order?
My lord, there is some problem with the reference, my lord. My lord, though
What
the,
problem with the FIR?
yes, my lord. My lord, all notice was issued only against the petitioner number 1 and 2, my lord. But they declared all the family members of the petitioner.
So what do you want?
My lord, I want the early hearing.
Early hearing of?
Any date, my lord. Next week.
No problem. You are on interim. Yes. Come up. Yes, since the record.
My-
Yes, next.
My lord, I date my fixed.
December did you? Yes, next.
20th December.
Obliged, my lord.
Lordship in item number 13.
20.
1-3, my lord.
Huh?
I am appearing, my lord.
Yeah, we'll hear.
Lordship.
We'll hear. Since the records have been received. Yes, next. Item number
15.
Jahura. Since the records have been received, the mayor will disappear. Yes.
Item number 16.
Suljan. Same order. Yes.
The interim shall continue, Lord.
Okay, interim order will continue. Yes, yes.
Item number 18.
Samsun Nahar.
Madam, Lordship will kindly fix in hearing stage, the interim may kindly be continued.
Okay, since the records have been received.
Interim may kindly be continued.
Yes, yes. Next.
Madam,
Supplementary list. Item number 24.
23. Rajiv Bhattacharya, they have done this. Huh?
23 mentioned. 24.
Adjourn. Okay. Then 24.
May I please, your lordship?
Yes, records have been received. We'll hear.
Lordship, in this case, I find IA lordship for bail,
IFF bail.
lordship.
Aisha Begum.
Aisha Begum.
You are in detention.
No, lordship, I am not detention.
You are in detention. Okay. IA.
IA.
And Mr. Lana Council will, yes, let him. Okay. In this in the interim. Yes, yes. The IA disposed of. Yes, next.
Applied.
Daily
Yes.
list for orders. Item 20.
Saddam Hussein. What is this criminal Saddam Hussein?
My lord, it's a red petition criminal, my lord.
But what is
So,
this?
come,
What does he want?
my lord, instruction has been received, my lord. So we may be allowed some time to file the affidavit, my lord.
Okay. Miss Das. You, no?
My lord, yeah.
Das Lanat Kang. For the state, we are for the state. Okay. For the state, submits that she has received instructions and may be allowed to file the same by way, file the respond by way affidavit.
Right.
List after how long?
3 weeks, my lord.
Yes, yes.
Item number 21.
What is this? Tilak Chetri. Tilak Chetri. Yes, madam, you are for whom?
A Gayan, Lordship.
Again, okay. And who is for Acharya Chaudhary? Non appears for the petitioner list after 2 weeks. Yes.
Supplementary list for orders 25. Item number 25.
Jamir Hussain, yes, what is this? I for what?
The I for my lord, correction of the name, my lord.
What is the
Actually,
correction?
my lord, real name is my lord, father's name and village is written correctly, my lord, in the IA, my lord. But in the inquiry report, my lord, while he went to submit, my lord, the SP said that no, in the inquiry report, I have written village name, my lord, Bormaville instead of Bormaville. Now that is the my lord, and father's name Abdul Salam. Here written as Abdul Salam. Only this commission, my lord, he has not accepted.
What you are saying?
My lord, what I have stated in my earlier IA, my lord, that is the correct name. Correct name of the village is Brumaville.
No, in the original proceeding, what is the how it is described?
My lord, the father's name was not village name was not described, my lord. State versus Jamir Hussain. In the opinion, my lord, in the repetition, my lord,
Page number
45, my lord.
in page 45,
Yes, my lord.
they are having the name Jamir Hussain to be foreigner. What is the description of Jamir Hussain?
No, my lord.
Huh?
There is no description, my lord.
No description.
No, my lord.
And this is also Jamir Hussain, na? Applicant.
Yes, yes.
But you are the son of
Son of originally Abdul Salam, my lord.
Abdul Salam. So what does the SP says?
Abdul Salam. Abdul Salam. And village name is original village name is Bromaville, and in the SP says his village name is Bormaville.
Oh, what the doesn't matter what, let the SP say whatever he wants. In the proceeding, you have been described as what?
Village
You
name was
haven't declared a foreigner.
yes, my lord.
In that, how you have been described, your name and village.
My lord, in that opinion, my lord, there is no description about my village name and father's name. My lord, but
How the okay, Mr. Pine will do one thing. Let him but this will be subject to final hearing. But
Yes,
we are
yes.
not accepting.
Yes.
He says he so let him.
That cannot be corrected by filing an
No, that is what we are not allowing to correct.
Yes.
He says he is that so and so. If that is so, if he says so, but then nobody has challenged this. Jamir Hussain, no Jamir Hussain has come to challenge. This has been challenged. He says that I am Jamir Hussain, son of so and so. Let it be accepted by the SP provisionally for
Yes,
the
sir.
purpose of bail, nothing else.
My lord, page 31, that is my lord.
Just a minute, written statement, page 31.
Yes.
You have
Yes, sir.
as far as Abdul, son of Abdul Salam.
Yes.
You have son Abdul Salam.
Son
Who
of
is
a
Abdul Salam?
resident of
Abdul Salam is his father.
Ah,
But in the SP inquiry report, he has been informed that his name, father's name was written as Abdul Salam.
in which, where Abdul Salam, where it
Abdul
is?
Salam, that is the SP's inquiry report. ma'am.
What is the inquiry report?
But I don't have with the inquiry report, but when he went to submit, my lord, they said no, in my inquiry report, it is.
But the
Abdul
inquiry
Salam.
report, we don't have, so we have to call for the inquiry report. LCR have to be requisition.
My lord, that report was called for, my lord.
Ah.
But what happened, my lord, while granting bail, my lord, since my lord, I have written my correct name, father's name and correct village name, my lord. But since the SP is written wrongly, my lord, so I need that wrong also, my lord.
Okay, but then unless we see the record, we can't say anything also. Likho.
Well, he is accepting only my, what I am saying, my lord, only father's name and village
Oh,
name
Baba,
should be allied.
Mr. Only what father, he changes. If you change the father, your identity changes.
My
There cannot be two fathers. Can there be two fathers?
No, my lord.
Then there has to be only one father.
No, my lord, he is in this.
Two fathers mean two children.
My lord, he is in detention camp. That is why, my lord.
Okay, we'll examine that. Likho then, Mr. Let the record be requisitioned by Tariq Didibo. Send a reminder to the Foreigner Tribunal Jorhat to dispatch the records without fail by next date. Tariq Didibo, we'll do that.
Short date, my lord.
Short date,
1612.
we'll do that. Yes, next.
Acknowledgement.
Yes.
Daily list, item number 22.
What is this? So if a list records have come, so we'll fix for hearing.
My lord, what happened, my lord, in this case, my lord, the petitioner himself is a police personnel, my lord.
So what? So you can be
So-
a foreigner can be a police personnel also.
My
You
lord,
can-
Lordship, LCR is also there, my lord.
Huh?
Only for 1 second, my lord, can you go to the inquiry report, my lord? Only the inquiry report, my lord. What is written in the inquiry
You
report, my lord?
becoming police does not mean that you are not a foreigner. According to a tribunal, you found to a foreigner. A foreigner.
My lord.
Inquiry report, let us see.
Can you see, my lord? Nothing has been written, my lord. Everything is blank, my lord. And from where I
Name Mainuddin, Mainwar, Tafazul, name constituency.
Nothing. Where from I am migrated, what is the scheme, nothing has been mentioned, man. That is totally mechanical, man.
Yes, Mr. Payam, what to do with this? You don't know from where he came, you don't know anything, so what to do? You don't even know he is from where.
That is the suspicion, my lord.
But then you have to give a reason that because of this, but you don't give a reason also.
I don't,
Whether migrated from Assam, no, yes, no, nothing.
I have not
If
gone through
yes-
the record, my lord, but.
Go through the record, yes. Go through the record, we'll take up next week or whatever. Have a look. Mr. Payam may look into the records. The metabolism again, what character is it?
812.
Yes.
Problem, interim will continue.
Interim will continue, yes. What was it?
Daily list of
Over. Aru
Delhi.
ki ase?
hearing list.
Key hearing list.
Item number 14.
Key,
14, Subramandal.
key hearing list. Criminal. Oh, criminal to nai. PPO also not there. Oh, you are there. But where is the other?
Subramandal is a part-heard matter, your lordship.
But they are supposed to argue today. Naki, today.
Jahan,
Today is listed today. Naki, fixed today.
Part 2 list.
Fixed today.
Not fixed.
They will argue today. They said.
Other side is also not there, Mr. BD Kaur,
Poor. Monday they must be busy.
doing motions.
That is, if lawyers have to think of the income also.
Yes.
Because this is no fresh income here. You have to survive on the old income for hearing matters. So what to
Something
do?
still give your lordship,
Huh?
daily
Daily, okay.
nowadays.
Daily bhatta, what is it called? So what to do now?
Subramandal, some other dates may be fixed.
Or tomorrow, from fix session again, tomorrow is the hearing day.
No. We can call.
Then we can, there will be, I think, today there will be in full form in motion items. Okay then. Yes. Matter stand adjourned for 3 weeks. 3 weeks. This also, her also Mr. Saiwala and counsel for the petitioner. Director,
2nd of January. 2nd of January.
yes.
Daily list for admission, item number 1 to 3.
Who was arguing?
Lordship,
We have already concluded.
Lordship, the matter may be passed over for the timing. Lordship, Mr. Goswami is in.
Okay, we'll see that yes, for a time being. Yes, next, call out.
Item number 4.
Mrinmoy Kumar Das,
May I please, your lordship, this matter may be passed over the time being.
pass for a time being. Then next.
Item 5 and 6.
Yes, 5 and 6.
My lord, here the facts of the case is different, but ultimately
5 and 6. Yes,
the central organization case is coming Here also in this case,
Which case? Central, central.
central organization, my lord.
Then you argue,
My lord,
Yes.
this in this matter, my lord, this is slightly different, my lord. What happened, my lord? The contract was signed, my lord, before my lord, the amendment, my lord, and my lord, the arbitration proceeding was also started, my lord, before my lord amendment, my lord.
proceeding had started.
Started, my lord. Now, my lord, since my lord, what happened?
Huh.
In the meantime, my lord, one of the my lord arbitrator, my lord, he was transferred.
Transferred.
So we wanted to replace him. my lord.
Replace them.
Now they have filed this petition that after coming amendment, my lord, this cannot be done, my lord.
Maybe,
Which is-
maybe, no, maybe because once the act comes into operation,
My lord,
had it continued, fine, we
Well-
correct, we understand.
my lord.
But then if a new has to be appointed in his
No,
place,
my lord, there are three arbitrators, my lord. Two are continuing, my lord.
okay,
Only one is, my lord. And there is a, my lord, judgment, my lord. I will produce your her lordship, my lord. In that case, my lord, when my lord arbitration proceeding started
already
before my lord
started.
amendment,
it will continue to be governed by the old act.
yes, my lord.
If that is so,
No, my lord. Either he will complete or I will.
No, my
start.
lord,
Whenever I start, he starts the
No.
submission. Let me complete first.
yes, yes.
Now, your lordship may kindly come to page number, my lord. I am coming to the notice, my lord. Page number 157, my lord.
Arbitration already started.
Page 1,
57, my lord.
oh, there's a volume of, who has given this petitioner?
I have given. my
Oh,
lord.
TRP,
Yes,
oh.
yes, my lord.
Oh,
TRFN also.
Oh. Okay. Just a minute, just a minute. Oh, I see. Oh, this case cited is more voluminous than the pleading, that's why I was wondering. Hmm. Page number?
First of all, my lord, I am coming to agreement. Page number 70, my lord. Arbitration clause is there.
Just a minute. Page,
Page 70, my lord.
70,
Yes.
arbitration clause. Yes,
Here the arbitration clause is same, but I would like to point out, my lord, page 71, your lordship may kindly.
yes,
The clause number 64, 3A1.
yes,
In cases where the total value of all claims in question added together does not exceed rupees 10 lakh, the arbitral tribunal consists of a sole arbitrator, who shall be either the general manager or a gazetted officer of the railway. So general manager is also empowered to act as a arbitrator. Not below the grade of JA grade nominated by the general manager. In that behalf, the sole arbitrator shall be appointed within 60 days from the day when a written and valid demand for arbitration is received by the railway. Now, next page, your lordship may kindly come to 72.
page,
Page 72, my. From bottom to this clause number
subject to 64.
64.7, my lord.
Ah,
Subject to the provision of aforesaid Arbitration and Conciliation Act 1996 and the rules thereunder and any statutory modification there shall apply to the arbitration proceeding under this law.
any statutory modification.
Yes.
So you are trying to say that if the modification met, there will be government.
Yes, it will, as per the agreement.
Correct. In that case, what will happen to those who are already, is a sole arbitrator or how many arbitrators?
3 arbitrators.
But you say it's a sole arbitrator, you are referring to sole arbitrator.
I pointed out that a railway manager is also, he can act as a arbitrator also.
No, 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 but which is the, see, is it exceed, does not exceed? Yours,
In
does
my
it
case,
exceed?
Yes, exceed.
I
In my
don't
case,
know.
the.
Then why you are referring to something which does not apply to you? Let us see which is exceeds.
64.3A2, my lord.
Then we'll read that. Why you are.
In cases not covered by clause 64.3A1, the arbitral tribunal shall consist of.
Three gazette officer, not
Yes.
Sancho, not Sancho, 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 Sancho. For this purpose, railway send a panel
Yes,
For this purpose, the railway will send a panel of more than 3 names of gazetted railway officers of one or more dependents, which may include the names of retired so and so, so and so. So, railway will send. Who is the railway? Which
the
railway?
general manager,
The general manager
yes,
will send a panel so and so, 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 so and so. Then she from asked to says, and will be asked to suggest to general manager. So from there, when a written bid demand is made received by the general manager, contractor will be asked to suggest general manager at least 2 names out of the panel for appointment so and so, so and so. General manager will shall appoint at least 2 so and so, so and so, so and so. Now, but then Mr. See the problem with suppose a 3. Now, our 3 out of the 1 has been transferred, so 1 needs to be replaced.
the facts is different, my lord, I am
Hmm.
coming today, facts is different.
Okay.
What my learned brother has said
Okay,
is
okay, no problem. 6332, yes,
Yes.
cover, yes.
Now your
Okay.
lordship may come to.
Because I have been influenced by his submission.
Yes,
I-
yes.
Okay.
My lord, your lordship may kindly come to page 157, my lord.
Page 157.
Yes,
Page 157.
on 4/9/2015, page 157.
49,
2015,
yes.
I invoke the arbitration clause.
How much is it? 2 crore? 2
Yes,
crore 83 lakhs.
2 crore 83 lakh.
Due so and so, various omission, commission, arbitrary manner, so and so, so and so. That I mean, being clause number 10 for settlement. Why is this clause 10?
This is part that I read earlier.
Oh, this is the clause 10.
Yes, part of the clause 10.
Okay, part of clause 10. Name a dispute. Okay, so on 4/9/2015,
Yes,
we
ma'am.
invoke. Then what happened?
Now, my lord, on 23/10/2015, the amendment was made.
23
10/2015. The,
amendment.
yes, the section 12(5) incorporated. And the schedule 6 and 7 also.
Section 12.
12(5). And
12
11.
inserted.
Yes,
Schedule also inserted.
yes.
Then
Now, after the amendment, this page 162, my lord. After the amendment, this letter was issued for suggesting 2 names.
26/10/2015.
Yes.
See, 4 people were there. You nominate.
Yes.
Please, at least 2 names of the following list: officer appointing 1 arbitrator and nominee from your side. Then you nominated,
Yes.
though knowing that you are that barred.
Yes. Despite that, there is no fulfillment of clause 12(5). There is no written
So
agreement.
you have waived that means.
No, there, unless and until there is a written agreement, I have not waived. This is the law.
This is your case, perhaps.
Yes.
Then is the arbitration going on right now?
No, not going on. Then again.
No, after you nominated the Harpal and the Makwana,
Yes.
then what happened?
Then
After they were
again, they started the arbitration proceeding after the amendment came.
Then
into-
you also took part, you appeared.
Yes.
Argued.
Initially, I appeared.
What do you mean initially you appeared?
Then next page, your lordship may kindly.
Next,
5/1/2016, the appointment was made by the general manager.
Page
164.
in
So
160
first, this was the first appointment made by the general manager.
appointment arbitrator in dispute so and so, whereas so and so decided.
Three
upon
arbitrators.
Then,
Then, my lord, your lordship, 5/1/2016,
uh,
the appointment was made.
uh,
And now, as per the section 29A, they were required to finalize the arbitration proceeding within 1 year. Now what happened? It was not finalized. Section 29, I am coming to your lordship,
section
29A.
arbitration to be finalized.
Within 1 year.
Hmm.
And if it is not finalized, the mandate of arbitrators automatically terminated.
Where is it? Section
29A. It is not their case that any extension is made either by the court or by the parties.
time limit for arbitration. That arbitration matters other than shall be made within a period of 12 months from so and so, so and so, so and so. If it is not made, what is that? Provided.
Yeah.
What is it?
Then your lordship, subsection 4. If the award is not
Not
made.
made within a so and so or so and so and so and so mandate of a shall terminate
Terminate.
unless the court has a. So that mandate gone according to
Gone.
you.
Yeah.
Once they are gone, then new arbitrator has to be
Yes,
appointed.
has to be appointed.
Then in that case, you say that there is no earlier
Yes.
chithi will not do.
Yes.
You have to have an express agreement.
Yes,
That is your case.
yes,
That's all.
yes.
That's all.
Now your lordship may kindly come to this.
Which one?
Next page,
Page
page 167, 66, my lord.
page 167.
166.
166.
Yes.
Yes, I have seen that.
Then they may, then
166.
they wanted to appoint the fresh arbitrators.
No, page 166.
Yes.
The reference decided to refer the dispute. We reference it was reference so Harpal, so Sapna Harpal resigned as however as per and upon new these two. When the arbitration started, because 1 year has to be done, no?
Yes.
When?
After that, after 5/1/2016, because after appointment, they can start the arbitration procedure.
Okay. SI has been pleased to nominate.
Now they wanted to appoint the fresh arbitrators. So they have also admitted that the earlier arbitrators appointed has gone.
Now, 2D6/7/2018, what did you say?
Yes,
You again agreed.
no,
And what is this
My reply is at
19/9/2018?
page 170, my reply is there. 170.
170.
With reference to your letter dated 6/7/2018, we would like to intimate you that in view of the amendment made in the Arbitration and Conciliation Act 1996, the railway officers have become ineligible to be appointed as arbitrator in relation to.
Now they consulted you before writing this.
Yeah.
Earlier they didn't consult,
Yes,
they proceeded.
yes, they proceeded.
Then after this, then what happened?
Then, my lord,
The page 170.
Yes.
170 is 15/3/2019.
then the matter is very interesting, my lord.
Everything is interesting in the court.
Yes.
Yes. That is
Now-
why the judges we are able to sit from 10:30 to 5. Otherwise, unless it is interesting. Yes.
Now, page 167.
Page 167.
Yes,
Now page 170 is the
is the reply.
reply of the petitioner, na?
Yes,
Then page
167.
167. What is that?
Now, what happened when they received my letter
Huh.
about the
Referring to
Pointing out
letter, then they proceeded to nominate. You choose
yes,
again. Same
nominate
process.
home, my lord.
Huh?
whom they given the name, ex retired officers,
huh,
4 names of the retired officer. Agreement does not say. Agreement says the working officers will be nominated by the general manager, not the retired. So this is against the terms of the agreement,
and also against the act,
law of the land.
law of the land. So on both count, they are
Yes, this is invalid.
invalid.
And they also, with this letter, my lord,
Yes,
with this letter, my lord, they sent a letter, format of agreement for waiving my right under section 12(5) and 31(5).
that you did, you agreed? No.
No, I did not agree.
What is that? What is the format?
Format next page,
Please.
my lord, 168. So they are also admitting.
They are,
Virtually,
now
they
they
are,
also started consulting their lawyer.
yes, yes.
One,
They are also admitting that the amendment has come.
168.
8
168. The format to waive,
yes.
format for waiver. Okay.
Then
Then
page 169, my lord,
then what happens?
I decline.
Decline.
Yes.
Declined by the petitioner. Then
I approach this honorable court.
that's all.
Yes,
That's the case.
this is the case, my lord.
Okay, Likho. And Mr. I'm just recording the fact.
Yes,
I will your submission. I will.
Yes,
follow.
yes, my lord.
Likho had Mr. Arushan Nane counsel for the petitioner who has the present petition file seeking appointment arbiter under section 11 of the Arbitration Conciliation Act for stop. The background facts leading to the filing of this application is that there was an agreement between the petitioner and the railway authorities for what? For construction or what?
Construction, my lord.
For construction of what?
Construction of, my lord,
For construction of
rebuilding of major bridge,
rebuilding of major bridge.
Buroi,
Where page number?
page number 24, my lord.
Page number 24.
Name of the work.
Okay, name the work. Huh? Page number 24. For execution of rebuilding of major bridge, Buroi, B-U-R-O-I, huh? Page 24, huh? Number 126 on the well foundation on permanent diversion at chainage 20/9-201/12 between stations Betti, B-double-T-T-I, Des Helem, including other ancillary works in connection with Gauze conversion of Rongia, Mukong
Select.
Select. Mukong Select, where is it? Mukong Select?
Here, near Tezpur, my lord.
It is. Is it towards going towards Arunachal or what?
Yes.
Towards Arunachal. According to petitioner, dispute having arose on account of, where is the notice? Please, your notice.
Notice, my lord, page 157.
157. On account of dispute having according to petitioner, as a dispute arose between the petitioner and the respondent railway authorities on account of various acts of omissions and commission on the part of the railway authorities, the petitioner raised a final claim amounting to rupees 2,83,43,986.19 on different heads, however, the railway authorities declined to make payment, resulting payment, and as such, since there is a dispute, which the railway authorities declined to make payment, and since there is a arbitration clause under the agreement entered between the parties on 15/9/2019 under clause 10 for settlement of dispute through arbitration, the petitioner wrote to the railway authorities for initiation of the arbitration proceedings. Pursuant to the said letter, white letter dated 4/9/2015, addressed to the general manager. Oblique cone. What is cone? Construction?
Yes,
Cone mean construction.
construction.
Okay, oblique cone, NF Railway, Maligaon. Full stop. Lanark Council for the petition submits that thereafter, the railway authorities responded to the same by their letter dated 26/10/2015. Am I correct?
Yes, my lord.
26/10/2015, proposing the name of four persons, out of which the petitioner was to suggest two names for appointment as one arbitrator, as a nominee from the side of the petitioner. Pursuant thereto, the petitioner wrote to the railway authorities on 16/12/2015, nominating two persons who were employees of the railways and then proposed by the railway authorities. Accordingly, the arbitration proceeding comments. Where is the 51164?
Yes, page number, my lord,
Accordingly,
164.
accordingly, on thereafter, the railway authorities appointed the arbitrators in terms of the agreement. Arbitration tribunal in terms of agreement consisting of three arbitrators, isn't it?
Yes, ma'am.
Three arbitrators. White, their letter dated 5/1/2016. Full stop. This next part. Lanark Council for the petitioner submits that though the arbitration was initiated, the unnecessary proceeding was initiated after the arbitral tribunal was constituted, as mentioned above. The arbitral tribunal did not conclude the proceeding within 1 year of the proceeding as mandated under Section 29A of the Arbitration Conciliation Act 1996. It has been submitted at subsection 4 of Section 29A of the Act further provides that if the award is not made within the period specified under subsection 1 or the extended period as provided under subsection 3, the mandate of the arbitrator shall terminate unless the court has either prior to or after the expired periods so specified extended period. It has been submitted that after the arbitration, it has been submitted that there was neither any direction from this court or from either of the parties to extend by the parties to extend the term of the arbitration. And accordingly, the earlier arbitral tribunal, which was constituted, the mandate of the arbitral which was constituted earlier shall stand terminated
By operation of.
by operation of law, as mentioned above. It has been submitted that in the meantime, the Arbitration and Conciliation Act 1996 also had underwent amendments, of which the relevant amendments, which are relevant for the purpose of consideration are provisions, insertion of subsection 5 to section 12 of the Arbitration and Conciliation Act, which provides inter alia that Section 12,
Yes,
Five,
my
Section 5, Section 12, which provides inter alia that notwithstanding any prior agreement to the contrary, any person whose relationship with the parties or counsel or the subject matter dispute falls under any of the categories specified in the 7th schedule shall be ineligible to be appointed as an arbitrator, provided that parties may subsequent to disputes having arisen between them waive the applicability of this subsection by an express agreement in writing. The said 7th schedule also inserted by this amendment, along with subsection 5 of section 12 of the Arbitration Code. According to Lanark Council for the petitioner, after having, after the amendment of the aforesaid act, obviously, any person who is in relation, who has relation with the railway authority, either serving or retired, would become ineligible. In spite of the aforesaid mandate of law, barring appointment of any person who has been or who has been or who is or who has been serving under the who is or has been serving under the Railways Act, the railway authorities again propose the name of 4 persons. Write their letter dated
6/7/2018.
6/7/2018, proposing the name of 4 persons, from which the petitioner was supposed to nominate 2 persons. 6/7. Then after this 6/7, page
I
160.
declined, my lord, page 170,
170.
107.
However,
170.
the said proposal of the railway authorities, railways, communicated to the petitioner on 6/7/2018 was declined by the petitioner by stating that in view of the amendment made in the Arbitration Conciliation Act 1996, any railway officer would become ineligible to be appointed as an arbitrator in relation to contract between railway and contractor, which was intimated to railway authorities by petitioner's letter dated 15/3/2019. However, the railway authorities, by ignoring the said letter, objection, wrote to the thereafter the railway authorities furnished an agreement for waiver under section 12(5). Furnished a copy of the agreement for waiver as provided in the section 12, proviso to section 12(5) of the Act, which the petitioner declined to execute. In other words, and as such, as a consequence, in absence of any waiver agreement in writing, the railway authorities could not have proceeded to appoint any person who is or has been a serving member of the railways. To stop. However, the railways, instead of doing so, proceeded to appoint certain retired members of the railways to constitute the arbitral tribunal, as informed to the petitioner via their letter 19/9/2018. It is submitted that such a course of action adopted by railway authority is not permissible under law, and accordingly, the petitioner has approached this court by filing this application under section 11 of the Arbitration Constitution. That's the
Yes, facts.
precise facts of the case. Then what do you want to say? Yes, anything?
Now, my lord, I am coming to the agreement.
Yes.
Page number 36, my lord.
Yes.
Contract agreement number so and so. Article of agreement made this day of so and so between President of India acting through the railway administration, herein called the railway on one part, and Messrs. Bhartiya Associate Private Limited so and so, herein called the contractor of the other part. Whereas the contractor has agreed with the railway of the performance of the work, rebuilding of the major bridge, Buroi number so and so, on well foundation and permanent diversion at chainage number so and so between station Bideti, Helem, including other ancillary work in connection with gauge conversion of Rangya, Murpok, select, set forth in the schedule here to annex upon the general conditions of and specification of the Northeast Frontier Railway 1998 edition. So in this case, already incorporated, which GCC will be applicable. Here it is clearly mentioned, both the parties signed the agreement is made by the railway agreed for the application of the 1998 GCC. Now, when both the parties entered into the agreement, both the parties are on equal footing. Whether the other party is government or not, as per the contract law, both the parties are binding by the terms and agreement of the contract. And unilateral, any amendment is not permissible by law. Now, in all the cases, they are relying on this central organization case, my lord. That is very. This central organization case, my lord, it is not applicable in our case. Here there is a very interesting thing coming in this case, my lord. I am referring this.
Central.
Yes, already I have given that. copy.
Yes, just a minute. No, it's okay. Yes, central organization,
Yes,
2020, no?
yes,
14, yes. Yes,
paragraph 2, my lord, I am coming to. These appeals have been preferred against the interim order dated 3/1/2019 and 23/9/2019 passed by the High Court of Judicature at Allahabad in arbitration, application number so and so. My lord, here one thing is there, my lord. This we are concerned with the Northeast Frontier Railway. And Northeast Frontier Railway is having its own GCC of 1998. This 1998 GCC, my lord, a separate independent, my lord, GCC, not related with the other railways.
so according to you, the GCC mentioned in para 2,
Is
in
part-
para 2 is
Yes.
different from the
other GCC,
from-
and it is particularly the GCC of Northeast Frontier Railway. We are concerned with the Northeast Frontier Railway. Which is here, my lord. Your lordship may have a look,
it is not in the pleading.
not in the pleading.
But then is it there? But is it correct, Mr.? These
No,
are facts.
No, my lord,
That's a no.
my humble
Okay, very no. Okay. But then you should find place in the pleading, Mr. Hussain. Otherwise,
Yes,
from your pocket,
yes.
he is coming out from your
Now,
pocket.
last time, because in the other cases, my lord, he raised the question of GCC.
No, correct. It is relevant, but
Yes.
then you should find place in the pleadings,
Yes.
no? Because the railway authority will be aggrieved, then they will go to Supreme Court, challenge it, and the Supreme Court say, where is this GCC? He is not there.
Yes, my lord. And
Then-
your lordship may kindly see, there are 4 other GCs. Subsequently, all the GCCs says that it will be applicable prospectively.
Anyway,
rather-
let us, but this particular GCC which you are referring to,
Yes.
let us go to that. Where is it?
Yes,
The particular GCC you are referring to?
yes.
You have given a copy to us also, no?
No, I am not.
Uh,
I
will
will
you,
give the copy, my lord.
and will you give a copy to Mr. Goswami also? Because they are eagerly
Yes, yes.
waiting,
I would like to give the copy, my lord.
but we have only one copy with you. So we'll circulate for the time being.
Yes,
huh?
yes.
First to court, then to the lawyers. Okay, by circulation. Sometimes we take decision by circulation in the administrative, no?
Yes.
We sign, okay, decided and circulate, one judge signs like that. So here also this document will be circulated. Engineering department, this GCC,
On the first page. on
first
the
page,
top-
yes,
Top on the
yes,
office frontier.
yes. Notice Frontier Railway,
Yes.
engineering department. Yes, what is that in this?
So this is a special GCC only for the NF.
But I don't know whether it is applicable in your case. How do you say that this is applicable in the present case?
Because it is mentioned in the agreement itself.
But this is 1998, okay?
Yes, 1998 is.
Oh,
mentioned.
edition, okay, 1998 edition.
Yes,
General conditions of contract and standard special conditions of contract.
yes, 1998.
Proceeding to annex to general condition of contract and specimen of the national contract edition corrected up to date. And that a special conditions, special specimen, if any, and in conformity with the drawings here annexed. And where is the performance ceremony? Okay, so this is that contract. In this contract, what is the difference
My lord,
between the with the central organization case and your case?
My lord, in this case, my lord, the arbitration clause incorporated here in the agreement is from this GCC.
Yes, correct. So let us see
And
this.
central organization railway, my lord, there the entire judgment does not say which
Which GCC?
GCC, only GCC.
So without seeing those terms of contract,
Yes,
you say, I don't want to be governed by this
yes,
judgment.
gone by that. Because that is made after the Honorable Supreme Court says about the GCC made after the amendment made in the arbitration act, my lord, by incorporating the waiver part.
Okay. Okay, yes,
Yes. So here, my lord, I am reading this one.
yes.
Because, my lord, this judgment was delivered.
Mr. You have seen? This
Yes,
is,
my lord, I have seen, my lord.
you have seen, no?
My lord.
You got a copy now.
My lord, if my friend permits, my lord, I can show, my lord. Is it applicable to all railways, my lord? It is.
Anyway,
published by Ministry
we'll
of Railway, my
hear
lord.
you, no problem.
Yes, ma'am.
But I just wanted to ask you, if you have the copy, then fine. If you have the- Yes, next, yes, Mr.
My lord, this judgment was delivered on 17/12/2019.
Hmm,
Now I am coming to the judgment, my lord.
yeah,
These appeals have been preferred against the impugned order dated 3/1/2019 and 29/3/2019 passed by the High Court of Judicature at Allahabad in arbitration application number so and so, in and by which the High Court rejected the contention of the appellant that the arbitrator is to be appointed as per general conditions 64(3)(a)(2) and 64(3)(b) of the contract and appointed Shri Justice Rajesh Dayal Khare as the sole arbitrator for resolving the dispute between the parties. The appellant awarded the work contract of rupees so and so to the respondent company by an agreement dated so and so, which contains the arbitration clause. Subsequently, after coming into force of the Arbitration and Conciliation Amendment Act 2015, with effect from 23/10/2015, the Government of India, Ministry of Railway, made a modification to the clause 64 of the general conditions of contract and issued a notification dated 16/11/2016 for the implementation of modification. The modified clause 64(3)(a)(2), where applicability of the section 12(5) has been waived off, inter alia provided that in cases where the total value of all claims exceed rupees 1 crore, the arbitral tribunal shall consist of a panel of 3 railway gazetted officers not below junior administrative grade or 2 railway gazetted officers not below JA grade and a retired officer retired not below the rank of the senior administrative grade officer as arbitrator. The procedure for constitution of the arbitral tribunal is provided thereon. Clause 64(3)(b) deals with the appointment of arbitrator where the applicability of section 12(5). This is, my lord, the difference. The procedure for constitution of the arbitral tribunal is provided thereon on clause 64(3)(b) deals with the appointment of arbitrator where applicability of the section 12(5) of the Arbitration and Conciliation Act has not been waived off. The clause 64(3) stipulates that the arbitral tribunal shall consist of a panel of 3 retired railway officers, not below the rank of the senior administrative officer as the arbitrators as per the procedure indicated thereof. Since the respondent did not complete the work under the contract within the period on 18/10/2017, the appellant issued 7 days notice under clause 62 of the general condition of contract to the respondent. Thereafter, on 27/10/2017, the appellant issued a 48 hours notice to the respondent, calling upon the respondent to make good the progress of the work, failing which the contract will stand terminated since the respondent did not make adequate progress in the work on 1/11/2017. The contract was terminated as per clause 62 of general conditions of contract. The respondent was also informed that their security deposit has been forfeited and the performance guarantee submitted by it shall also be in cash. Now, I am coming to the relevant portion, my lord. I am skipping this facts of the case, my lord.
There's the students or what? Huh? They are not having the space to.
My lord.
Students,
My lord.
they are standing there all.
Student, my lord. Yes, my lord.
Students, let him sit, let him sit. The student standing has a different connotation.
Yes.
Lawyer standing is no problem because lawyer is supposed to stand. That's why we call standing counsel also. So if the student stand, there is some problem with the student. Otherwise, the student is supposed to sit. Yes,
My lord, I am coming to paragraph 10, my lord.
yes, paragraph 10.
Yes. We have carefully considered the submissions and perused the impugned judgment and materials on record. The point falling for consideration is whether the High Court was right in appointing an independent arbitrator in contravention of the 64(3)(a)(2) and 64(3)(b) of the General Conditions of Contract. The learned counsel for the respondent submitted that being serving employee of the appellant, the panel of arbitrators proposed by the appellant white letter dated 24/9/2018 were not eligible to be appointed as arbitrators in view of the provisions of section 12(5) read with Schedule 7 of the Arbitration and Conciliation. Learned counsel further submitted that the panel of arbitrators proposed by the appellant white letter dated 25/10/2018 comprising of retired employees of the appellant were also not eligible to be appointed as arbitrators under the section 12(5) read with Schedule 7 of the Act as the employees of the appellant are expressly made ineligible. In support of the contention, learned counsel for the respondent has placed reliance upon Postal Pine Shinen GmbH versus Delhi Metro Corporation Limited. So here also important point was discussed in this case, my lord. The amendment provision puts on an embargo on a person to act as an arbitrator who is the employee of the party to the dispute. It also deprives a person to act as an arbitrator if he had been the consultant or the advisor or had any past or present business relation with the DMA. So as per this judgment, my lord, ex-officers of the railway, retired officers of the railway are also ineligible. On behalf of the respondent, reliance was placed upon Bharat Broadband Network Limited versus United Telecom Limited, wherein the Supreme Court held as under. Section 12(5), on the other hand, is a new provision which relates to the de jure inability of an arbitrator to act as such. Under this provision, any prior agreement to the contrary is wiped out by the non-obstructive clause in section 12(5). The moment any person whose relationship with the parties or the council or the subject matter of the disputes falls under the 7th schedule, the subsection then declares that such person shall be ineligible to be appointed as arbitrator. The only way in which this ineligibility can be removed is by the proviso, which again is a special provision which states that parties may subsequent to the dispute having arisen between them waive the applicability of section 12(5) by an express agreement in writing. What is clear, therefore, is that where under any agreement between the parties, a person falls within any of the categories set out in the 7th schedule, he is, as a matter of law, ineligible to be appointed as an arbitrator. The only way in which this ineligibility can be removed again in law is that parties may, after dispute have arisen between them, waive the applicability of this subsection by an express agreement in writing. Obviously, the express agreement in writing has reference to a person who is interdicted by the 7th schedule, but who is stated by the parties after the dispute have arisen between them to be a person in whom they have faith notwithstanding the fact that such person is interdicted by the seventh schedule. Per contra, on behalf of the appellant, Mr. So and so, has submitted that the appointment of arbitrator is governed as per clause 64(3)(a)(1) and 64(3)(a)(2) of the general conditions of contract, where here also the year of the GCC is not mentioned, my lord. Where
But, it has been quoted also.
not quoted. This is the, my lord, problem.
64(3)(a)(1), not quoted.
Not, and this was after
But you
the,
mean to say that these 64 clause, these are different in different editions?
yes, different edition. I have all the other editions.
Okay, very well.
There I find.
Okay,
my lord.
okay.
For contra, on behalf of the appellant, Mr. So and so has submitted that the appointment of arbitrator is governed by as per clauses 64(3)(a)(1) and 64(3)(a)(2) of the general conditions of contract, where applicability of section 12(5) of the Arbitration and Conciliation Act has been waived off, and the arbitral tribunal shall consist of a panel of 3 serving railway officers or 2 serving officers and 1 retired officer. Learned ASG submitted that clause 64(3)(b) of GCC deals with the appointment of arbitrator, where applicability of section 12(5) of the Act has not been waived off. It was further submitted that clause 64(3)(b) of GCC stipulate that the arbitral tribunal shall consist of a panel of 3 retired railway officers, not below the rank of senior administrative officer, and the arbitral tribunal shall be constituted as per the procedure indicated thereon. So here the question of retired railway officers is there. In my GCC, it is not there. Placing reliance upon the Union of India versus Farmer Construction Company, so and so, Union of India and Pradeep Vinod Construction Company, so and so, Learned ASG has submitted that when the agreement specifically provides for appointment of panel of arbitrators, the appointment should be in the terms of the agreement, and the appointment of independent sole arbitrator is in contravention of general conditions of contract which govern the parties for appointment of arbitrator. Clause 64 of the general condition of contract deals with the procedure for resolution of dispute and provides for demand for arbitration and appointment of arbitrators. Clause 64 of general condition of read as follows. Now here, the 64(1)(1), in the event of any dispute or difference
It
between,
is quoted here, 64(1), this is quoted.
quoted the earlier part. First part is relating to the earlier matter.
No, this 64 which is quoted is what?
Yes, this quoted,
64 deal with the procedure for resolution. This is the amended one as per notified. See there,
Amended-
see.
amended
see-
one.
No, see, in the beginning, you have mentioned that
GCC,
issued a notification,
Yes.
made a notification of clause 64
Yes,
and issued a notification dated 16/11/2016. Therefore, this, the one which you are reading, is it
Is-
the modified one?
modified one, madam. Because here one, another clause is added, my lord. 64(1)(2) is added. 64(1)(2)(b) is added.
Sixteen, 11, 2016.
But year is not mentioned, my lord. GCC of which year?
In this 64(1), so 64(1)(2)(b) incorporates section 15(2).
Yes. My lord, this judgment was delivered in 2019, my lord. And what the GCC 2018 says, my lord? The GCC November 2018 shall be applicable towards contract on Indian Railway with prospective effect.
Which one? Which one? Which GCC you are reading?
This 2018, my lord.
18, which is referred in this case? In central organization?
Amended portion is referred, my lord. Matlab, which year of GCC it is not mentioned, my lord. Because this was delivered in 2018. Suppose we take that 2018 GCC was modified, then also it itself says, my lord. GCC November 2018 shall be applicable towards contract on Indian Railway with prospective effect. GCC itself says,
So which is the GCC you are reading?
this 2018. Then again, my lord, in 2019, I am coming to that.
No, but then this para 15 of this judgment, you mean to say this para 15 of judgment has not referred that it is of a prospective effect?
Yes. It has not been submitted by the petitioner. It should have, ought to have been submitted, my lord.
So
It
you
was
want
not
us to
put to
decide, you want us to, this court to decide on the
No, my lord.
legality of this judgment of
No,
Supreme Court?
just, my lord, I am clarifying the distinction, facts of that case and this case, my lord. Here my submission is different, my lord. This submission is not there before the Honorable Supreme Court, my lord. So facts of that case and facts of my case is different, my lord. Because facts of every case depends on its own facts, my lord, as you should know. So when the facts is varying, my lord, and here, my lord, there is another point also now. Again, recently, 3 judgments, my lord, before this.
So you are
Yes.
trying to distinguish the central organization case
Yes.
applicability
Yes.
in the present case.
And again, my lord, the 3 judgments recently, again, it was referred, this central organization case report for a larger bench.
This is Rohinton Nariman, that one?
No, that was the earlier one. That was
Okay.
Tatia Construction.
Tatya,
Now
okay.
there is another recent,
Another also. Why it has to be referred again and again?
again, it is referred, my lord,
Oh.
by 3 judgments, my lord. And here one thing is very important, my lord. Though it is mentioned in this central organization case, my lord, the Honorable Supreme Court in the paragraph first, the emphasis is given. The basic issue involved in the instant matter is whether the appointment of arbitrator was.
Now, if that is so referred, now what do we do then? Shall we keep this pending?
My lord, here there is a
Now, what is the observation?
observation is that since the issue has been reoccurring, we may observe that-
It will be in the fitness thing the question resolved earliest.
I-
So we'll wait for the earlier resolution.
It is up to your lordship. This is the problem, my lord. Whether we should wait or whether we should
You see,
proceed.
the problem will arise if either we say that this court says it is not at all applicable and the facts of the case, then we'll go by the normal law.
Yes.
But if you say that yes, they will refer, so we shall await, then we'll wait.
Yes.
As a counsel, as a officer of the court, what is your view? Not as a counsel of your Mr.
My view is that
uh,
because here in Honorable Supreme Court, it is how
not as a counsel of Bhartiya, but the officer of the court, what is your view?
because my lord,
What is referred?
here my lord.
If you are asked to give a lecture in a law college, what is your view?
It is, my lord, better to wait.
Wait.
Here, my
But
lord,
Mr.
because
Kaushik Goswami says, please don't wait, please decide. So we'll ask the same question to Mr. Kaushik Goswami also. If he has to give a lecture on jurisprudence, when there is such an observation whereby when the matter is referred, what shall be the duty of the court?
because already matter is pending in the Honorable Supreme Court. And going here and there, my lord.
And Mr. Goswami also to take same view, or you said no, central is central.
No, my lord, that.
So what is your view?
Admittedly, my lord, that has been referred. to
Referred.
last-
So what is your view?
So my lord, my view is, my lord,
Wait, wait for
my
the
lord, since my lord.
wait
as
for
per-
the larger view.
Yes.
Our larger
Yes.
view of the larger bench.
Exactly, my lord.
Until then,
And
what will happen? The status quo.
Yes,
it is, because my lord, my.
because
case is
again,
what-
either they will go or I will go to same problem. Right? It is better to wait here instead of going to higher.
I'm sure it will be decided because because arbitration, one of the reasons, amendment to the Arbitration Act was made as per the UNCITRAL.
Well,
UNCITRAL, as you know, it's a kind of universally accepted principle to resolve dispute at the earliest.
my lord.
Now, if because of this, now not only this, there may be other cases also in other in other states also
Yes,
arising out of railways.
yes.
that all will be stored.
Same question raised in the Patna High Court.
Then what did the
case,
Patna
my
High
lord.
Court say? What did the
There
Patna?
also, this problem is there, my lord.
Then what did the Patna High Court say?
It is still pending, my lord.
They have not given any
Yes,
view as to wait or will decide.
yes.
So at least Patna High Court is there. Any other High Court?
My lord,
Because see, now this is something because Goswami has argued, elaborately for days, that, this court, this central is not applicable, therefore court may proceed. Then of course, you are also arguing that in the facts of the case, central does
Yes,
not
yes,
apply.
yes.
And for saying so, you are trying to distinguish the central
Yes.
from the present case. When it is very clear cut, because see, every decision has to, the decision of the Supreme Court has to apply on the facts of each case. But
Ultimately, my lord, the main argument of the railway is also coming to that on the central organization.
Mr. Goswami, just a debate, nothing, just a discussion. Because see, here also, Mr. Goswami has come up with central, flag of central organization. I am decided. So, doesn't matter whether, doesn't matter here. Then Mr. Hussain also feels that now this has been referred by another latest decision of the Honorable Supreme Court on
Yeah.
16/8/2022.
Still.
GSW Steel versus Southern Railway. Again referring.
My lord,
Now, once the Supreme Court also sees of the matter,
my lord.
and as we know, arbitration proceeding is meant to be expeditious disposal of disputes. Lay off court's hands, refer to a arbitrator so that dispute. And in fact, this is one of the reasons why India's ranking in the ease of doing business has risen
My lord.
in the world. And if the arbitration matters pending all across because of this pendency of this matter, therefore I'm sure the Supreme Court will take it up at the urgent. So Mr. Hussain has suggested that we can await decision of the larger bench. That will be
Not necessary, my lord, because if the issue is connected, my lord, today, in fact, I was supposed to give reply to the arguments made by railway in my cases 1, 2, 3, my lord. So my case before your lordship would be that the central organization case is not at all applicable. Not at all applicable. So let me, Mr. Hussain finishes his case. After that, perhaps your lordship will take up my matter, my lord. I'll place that. Your lordship don't have, and perhaps need not go into all this, because once your lordship held that is not applicable, then the question whether that is a your lordship need not go into all those questions, my lord. First is the applicability. Now, as I understand, my lord, from their argument, the only reason they say that central organization is applicable is for one reason. What is that reason? That in both cases, the agreements have been signed prior to the modification. That is only a fact. The rest of the things will also have to come, my lord, because the decision is not about what is the common facts. The decision has to be what is argued, the reasons, the ratio. That has to be seen.
But then Mr. Goswami, then we are going into that one area,
My lord.
forbidden area, that we are examining.
Not go into that area. Why?
Forbidden area, whether the Honorable Supreme Court rightly decided, whether Honorable Supreme Court could have ignored this.
Your lordship need not go into that for two reasons, my lord. First, as I said, my lord, the issue that has arisen in the proceedings before your lordships has not arisen in that case, number one. Number two, I have already shown the 3 benches judgment, my lord, where this principle has been already decided. That once the requirement is that there has to be an express agreement in writing, unless you waive, no other way one can appoint someone from their own office. That has been decided by the 3 judges bench. Then comes central organization. Now, when there are 2 contrary decisions, the Supreme Court decision is already there that your lordship will be bound by the earlier one. That is by TRF. Your lordship need not go into so many aspects, my lord. Everything is very clear. It's a very short matter, my lord. Everything is before your lordship. Now, if something has not been discussed, not argued, how your lordship would be binding by that decision? Those issues did not even arouse before the Supreme Court, with utmost respect, my lord. It is very clear, my lord. Simple English, it is written, it's very clear. The only thing I found which is common is that in both cases, the agreements were before.
My lord, one.
And my lord, most importantly, my lord, in central organization, they say, what was the basis of giving that decision? The basis is that because of an express agreement in writing. Now, whether in that case, after the modification, what correspondence happened, those things are not reflected in that judgment with utmost respect.
Therefore,
Yes,
but indirectly also we have to make an observation. If you, as
Yes.
per your argument,
yes,
that while the Honorable Supreme Court deciding the central organization did not really consider these issues, therefore perhaps it is not a good, it will not have, not good, you may say,
yes.
that it will not have a precedential value.
What I would, how I am seeing the matter, my lord, is that perhaps since this issue has not arisen, perhaps for that reason,
Therefore-
that may
therefore-
not be a law in this.
Therefore, this the decision of the center will stand on its own.
Exactly.
Now, if that is so, the Honorable Supreme Court could also have made an observation in Southwestern Railway also, but the Supreme Court said, we'll refer to a larger bench.
Now, your lordship will have to see, these are 3 judges bench.
Correct.
So
No,
therefore, when there
I
are
will
2
also
contrary
presume.
decisions,
No, but
the best
TRF,
is to
correct,
refer.
but then TRF also referred.
Yes.
See, if you see,
Yes,
kindly
yes.
see this judgment, just which have been, Mr. Hussain has, see, the basic issue, para 1, the basic issue involved in the instant matter is whether the appointment of the arbitrator was in conformity with the law laid down by this court in TRF and Perkins Eastman.
Yes, Perkins is also very important.
Now, the High Court has gone by decision rendered by a bench of 3 judges in central so which decision had distinguished applicable TRF so and to the facts which are involved, and we have to notice subsequent a bench of 3 of the so Tantia is expressed. Now, in the light of this, the Supreme Court also was seized of this matter when it referred
my lord,
TRF.
yes.
But then Supreme Court could have taken the same view as you have expressed by you also.
My lord, I don't know
Rather-
the facts in this case.
No, that is why,
but-
no, I understand, Mr. C. Kaushik, because we are, entering into a very delicate area. I mean, with all respect,
My lord,
we appreciate, this court appreciates your submission advance.
my lord.
But then, now, that obviously, I would presume, not expect, I would presume that similar perhaps submission might have been raised also in Supreme Court. Might have said, my
Well,
lord,
there's
see,
one
the TRF
difficulty
is
here, my
there,
lord.
therefore this cannot be a good law.
My
Because
lord,
TRF,
what happens, my lord, when it's a coordinate bench, my lord, if one
but
is
but
faced-
I'm averse in coordinate bench. I mean, I am
No,
a
but
lesser
at least your
lesser
lordship
place to.
has the
No, but then
in
correct,
front of
I
your
agree
lordship,
that.
his lordship has one decision where the issue has been discussed and a decision has been given. Then your lordship have another decision where the issue was not even discussed.
Even the coordinate bench of
If-
the Supreme Court have also could have said, see, we have agreed, we have
Well,
examined.
that perhaps may
TRF
not be, my lord, because all these decisions that I am carrying, my lord, they say that normally a coordinate bench should not make comments. Best is to refer if it's a coordinate bench.
But then my position is lesser than a
My lord,
coordinate
why
bench.
I'm saying, my lord,
I am just see, I have to follow what the Supreme Court says.
my lord,
Yes,
you're-
sir.
absolutely, but your lordship
Therefore-
will follow the law laid down by the Supreme Court. So before your lordship,
But
there
then
has to be
coordinate
law.
bench also could distinguish it, because we also distinguish our coordinate bench.
My lord,
We say that,
in-
yes, these are not a fact, these are not available, applicable in the facts of the case, therefore.
My lord, in
perhaps-
central organization, there are a couple of other things also that has been discussed, my lord.
No,
Now, those
correct.
we are not related to.
No, see, we have understood
Yes.
your submission. In fact, I was thinking that, but then again, Supreme Court has referred to a larger bench by referring to TRF and Perkins.
And my
My
lord,
lord, it has been done because already Tantia has referred it, my lord.
No, correct, but
Now,
then
the
I'm
three
sure,
judges bench has
no,
already. referred it.
I'm sure perhaps this issue might have been also raised at
No, my
some
lord,
point
if
of time.
If we go by this, my lord, I understand your lordship's anxiety, my lord, but perhaps, my lord, I may be wrong, but it appears in paragraph 3, if your lordship kindly see of this judgment,
Yes.
it has been brought to our notice that subsequently a bench of 3 judges of this court in Union of India versus Tantia Construction, vide its order dated so and so, prima facie expressed its disagreement with the view taken in central organization and requested the Honorable Chief Justice of India to constitute a larger bench to look into the correctness of the decision in central organization. So this has already done. And
Correct.
therefore, this three judges bench, since it has
Correct.
already been referred,
Correct,
so
correct.
let it go.
I also assume that in
So the correctness of
JSW
central
still court,
organization
they might
has-
have also argued. I mean, I'm assuming, I'm not saying that it was argued. There is perhaps a possibility that this also, say, my lord, say TRF has already larger decision, larger bench has already decided, therefore it should be followed. I'm sure, I mean, because see, we are talking of Supreme Court, therefore I'm sure the lawyers might have also.
Well, TRF and central organization, Tantia, Jaw still all coordinate benches, all equal benches. Now, in Tantia construction, they have already doubted the correctness of
And
Central.
according to TRF being an earlier decision, well reasoned and having taken care of all the aspects
Yes.
of
yes.
this arbitration should be followed. That is
I am not
there's a
saying
good
all
law.
aspect. What I'm saying is that because ultimately your lordship have to see what is the issue before your lordship. Then that
No,
decision.
no, I have understood what you are saying, that there are two decisions before us.
Yes.
Before the High Court,
Yes,
TRF and the Central.
and I'm
And you
saying,
say that TRF has more or less discussed all these
well,
aspects.
I'm only saying the issue that has arisen in my case has been discussed and decided in TRF. This is my argument before your lordship. Because what I'm arguing, if it's not considered in central organization, how can I say central organization is a law applicable in my case? That will be against all the settled positions of law. What is ratio? What is ratio decenti? What is principle? All the settled positions of law would be disturbed, my lord. Then any statement made in any decision will be applicable.
But then see the JSW still could have also taken the same plea.
Why not? Because Tantia
Correct,
has
correct.
already referred.
No. Even in spite of that, JSW still could have also argued in the same manner. See, my lord, already TRF is there, which is applicable to us. The same applicable, therefore, TRF, let us follow TRF. Let it be decided at a larger bench later on.
Perhaps
Perhaps.
in Jaw still they could have done that.
Ah.
But when already three judges bench have already said that central organization is a bad law and needs to be referred, and accordingly has referred it to the Honorable Chief Justice, then my lord, perhaps
Therefore, in this case also, even if I decide
my lord,
this.
your
in
lordship
your-
will not be deciding
No,
on
no, no.
central, my lord.
No, correct. Even if I did, no. I will be deciding that central is not applicable.
My lord, that is what I'm saying, my lord. The
No,
easiest
no,
way
in
for the
the,
lordship would be
yes,
to
so
say
what,
the issues
I'll-
have not been
correct,
decided.
correct. Therefore,
Yes.
central is not applicable.
Correct.
Ah.
Your lordship is saying that. Your
Correct.
lordship is not deciding whether central is
Correct,
good or
correct.
bad.
Good or bad, but then I said it is not applicable.
Yes. On the facts of this case.
Then they will say it is applicable.
Well,
And this was
that-
raised,
if they have
and
to
this
say
should have
it's
been-
applicable,
this should
my
have been-
lord, they will have to show that in central, the argument was made and there is a decision. They have not shown that. What did they show? From the entire judgment, they only showed before your lordship that the agreement has been signed prior. This is what I have been briefed by my junior, that this was the argument, that the agreement is common. That is common. They could not point out a single sentence from the judgment that there has been an argument made that once an agreement has been entered, their parties are bound by it. And subsequently, you cannot modify something and make it bound unless the parties agree. The proviso to subsection 12 has not been argued there, that the only way to save one is by way of an express agreement in writing. This has never been argued. Unless you argue this, how can this be applicable? This has to be, and there I found, my lord, I will place it, my lord. If my learned friend has finished, my lord, I will show it to your lordship that simply it has assumed in one paragraph that there is an express agreement in writing. Which is this express agreement in writing? That modified clause. Without going into the question whether that retrospectively it could have been applied, specifically in context of agreements, because agreements are between parties. And as my learned friend has shown, similar clause also exists in my agreement, where the parties have said that what are they bound by? They are bound by the GCC and up-to-date GCC. So up-to-date means as on that date, not something that subsequently comes. These questions have to be argued with utmost respect, my lord. And whether the facts were different or we don't know, because these things were never discussed in central organization. Therefore, according to me, that law, whether irrespective of the fact it is good law, bad law, without making any comments, that law is not applicable because there is no law there as relating to this part of the issue. First, this part of the issue has to be decided. Because here we are bound by an agreement. According to my agreement, whatever we are bound by, now it is hit by section 12. The named arbitrators have become de jure. The only way one can cure it is by way of an express agreement in writing by both the parties. The statute provides. Now, where is that agreement by both parties? They are relying on a modified clause. Have I signed that modified clause? I have not signed. How can you make it applicable in my case? This is my argument before your lordship. If they can show that in central organization this has been discussed and there has been a principle has been laid down, then I rest my case, my lord. I'll be bound by central organization, irrespective whether it's a good law or bad law. But if this has not been discussed, that cannot, with utmost respect, my lord, then that is not a law under Article 1. It will not be a binding precedent. I have already shown many cases. In fact, your lordship would recollect, I have shown 2014, which is if there are two decisions of equal strength, almost similar on the similar subject, and both cannot be reconciled, then the earlier will stand. Here, even if that situation arises, before your lordship, TRF is there. In TRF, this has been decided in details.
You're correct. See, the problem is that now this JSW still has little bit, added to the confusion, because see, in spite of this, okay, we could still Tantia construction, okay. Now JSW again says the TRF with specific reference to TRF
My lord.
in para 1. Loaded down this code TRF so and so so and so.
And Perkins man.
Perkins.
This is also
So the Honorable Supreme Court could have made some observation. Well, TRF perhaps is because it will have a more presidential value, because TRF has discussed all this, taken into aspect 12.5 and all this, but then unfortunately it was not taken
that
to.
was not done.
Then done. See, the same thing we are expecting this court now, and therefore I am little bit on that aspect. See, the thing which you are expecting me to do this.
Your
I have no
lordship wants
interest.
to wait for the outcome.
That is why, because see, the problem has been because the Honorable Supreme Court, see, they must have been also aware that yes, perhaps the facts are not different. In that case, they could have made an observation. In that case also, JSW still. But then out of deference, whatever it is, then why not this court also out of deference to these views, wait for the decision of the larger bench? Because we are entering an area now. Correct. No. But this is also another plausible way of thinking.
Yes.
We don't know.
Your lordship is right. One
We
way
don't
is
know
that.
how one way is also there.
Till
Yes.
this is decided.
Then maybe Supreme Court said, I don't know why the High Court decided in this manner when we have already referred
it to a larger
bench, even this case also.
Well,
That is a little bit of
that could be
concern.
one
I mean,
possible-
now because
Yes,
of purely judicial propriety, not that.
Right,
no,
right.
not-
Since because
That is
I understand.
this is
my
also
lord, because
possible view.
The issue is now in front of the Supreme
Supreme
Therefore,
Court.
one
It is-
way is
yeah.
that- Wait,
Wait.
your lordship is absolutely correct, my lord. But only thing is, my lord,
No, I have understood. That
Yes.
is what I was thinking initially. But then now today, Mr. Hussain has produced this again another order. Therefore, now confirming that now Supreme Court is fully seized of the matter. Yes, there is some serious issue in the light of TRF about this central. They still opted to refer to a larger. Okay, we'll wait also. If the Supreme Court opts to wait for, then what is the hurry for this High Court to hearing?
that could be one way.
Because same thing, because in this case also, perhaps because of this reference, everything must have come to a standstill.
Absolutely.
Even then, the
Yes.
matter which is brought to the SLP,
Yes.
must have been, there must have parties, see, the matter has been referred to a larger bench.
Yes.
So please don't pass any order.
Yes.
I'm sure they must have gone to the arbitrator and said, and arbitrator, okay, we'll wait.
Then that could be one view, my lord.
Because
Absolutely.
if we are doing with judicial proprietary.
True, my lord.
Because
Because
not
my
that,
lord, yes,
because we
paragraph
don't
is-
want to cast any kind of question mark on a judgment of the Supreme Court. More so, because there will be some kind of, see, we'll be saying, some observation has to be made. Why it is not applicable? Why central organization not applicable? We will say, no, this was not discussed. This was not discussed. This was not discussed. Therefore, it is not, this is not applicable in the present case. That itself, there is nothing wrong with that. We do that. That in this Supreme Court judgment applying the facts of the case. Very well. We do it. But here, the issue has even reached Supreme Court. They are also
The
totally
seized of the matter.
seized of the matter. Still, they in their wisdom, they thought that since we have referred to a larger bench, we'll wait.
Your lordship,
I
that
think
could
because
be
that's
one way.
one, because that is what I feel.
If your lordship is of the view that similar issues are there, then of course your lordship may.
Perhaps because
wait.
we are
But if
entering
your
into a
lordship-
slightly no, I understood. I appreciate your submission made. In fact, that is what I was thinking. Maybe we can say that. But today, Mr. Hussain again produced another judgment direction of the Supreme Court referring. Therefore, the
But
Supreme
probably in Supreme Court now, there could be a fourth, fifth case also, because any case that comes, because the Tantia has referred, my lord, obviously, my lord, no
See, but
prejudgment
whatever
will decide.
that still, Supreme Court is Supreme Court.
Correct.
No, we cannot presume anything
Yes.
because that's what the
Correct,
fact.
my lord, your
I
lordship.
think
leave
that
it to your
is,
lordship.
I feel that because rather than because we have understood, that is what Mr. Hussain also trying to portray. The facts are different here in this case also.
I leave it
Facts
to
are
your
totally
lordship, my
different.
lord.
I understand, but then say that no. Therefore,
The only difficulty that we will face, my lord, is because high stakes are involved. my
right.
lord.
But then
That is the
similarly,
problem.
this also,
Yes.
this must also high stake. The
Before,
when
my lord, as I said, my lord, as per.
correct
my
because
argument
by
before your lordship-
doing so, we'll putting a stop
Yes.
seizure to any proceeding,
Yes.
either by arbitration
And
or
my situation here is because I'm saying, my lord, what the issue that has arisen in my cases were not the issues before the Supreme Court and
correct,
central
correct,
organization.
correct. No,
So
because
the two aspects of the matter, your lordship may decide one, my lord, either your lordship wait or your lordship.
no, I can make your observation of a submission, but then still I prefer that the matter be
Very
you
well,
know,
my
with-
I leave it to your lordship.
because of this latest one. Till that
Your
earlier,
lordship may record my submissions
Uh-huh.
and then your lordship
yes,
may
yes,
say that.
it'll be appropriate. I think I think that will be
Yes.
better.
Otherwise, my lord, we are sometimes misunderstood.
Correct, that is true. Then perhaps we can decide both now, we refer it to a wait for the larger bench then. We
Yes.
can,
Yes,
because Hussain also.
My lord,
because-
let him finish, my lord, then if something is there, I will say. no.
Okay, very well. But then Mr. Hussain, he's agreeable to wait for that.
yes.
If I pass the order, then obviously,
The same order.
then same order I have
Same
to
order.
follow.
Ultimately, the result will be same on
Well,
based
only-
on that.
I'm saying is that your lordship may just record my submission and then your lordship may say that, however, it would be prudent to refer.
Yes, yes,
Wait for the citizen.
yes,
Just my submission may be recorded
yes.
because my submission before your lordship is that the issues are different and that has not been decided there.
I don't know if I have recorded your
Yes,
submission
yes, your
earlier
lordship
also.
have recorded once. In fact, we've given a detailed
yes.
note also.
If that is so, I can, Mr. Yes, I will
Yes.
get your order also.
Yes.
Mr. Having heard Mr. Kaushik, I can record now.
My lord.
The brief, the submission in brief is that the fact situation obtaining in the present case is totally different from the fact situation which was considered by the Honorable Supreme Court in central organization.
But it's not facts, my lord. That fact is same. The issue that I have raised, my lord,
Okay.
question.
The issues raised by this ways in this bill and also considered in TRF case were not discussed at all by the Honorable Supreme Court in central organization case. And as such, in his view, the decision rendered by the Honorable Supreme Court TRF case would be more applicable than the decision in the rendered by the Honorable Supreme Court in central organization. Because I have referred all, I will,
Yes,
I
yes,
will,
yes.
I'll mention
Yes, my
all in
lord. Yes, my
detail,
lord.
all
Yes,
those
my
submission.
lord.
Submission. Full stop. And accordingly, they have been submitted that this court may go by the decision in the TRF and proceed to appoint the arbitrator in term under section 11 of the section. On the other hand, Mr. Goswami, learned counsel for the railway authorities, has submitted that central organization decision remains remains and has not yet been overruled by any larger bench of the decision, and which is applicable. And since the fact situation are similar in the present case, this court may not ignore the decision rendered by the Honorable Supreme Court Central Organization. It has been submitted that in the Central Organization, the fact remains that the Honorable Supreme Court allowed the arbitration to proceed with an employee, ex-employee, no, in ex-employee of the railways, in view of the modified terms of agreement, which was notified on 16
Modified terms of the
modified
GCC,
which was notified on 2016. Full stop. Thus, it can be said that the Honorable Supreme Court was not aware of the bar imposed under Section 5, subsection 5 of Section 12 of the Arbitration Conciliation Act. And as such, it can full stop. Having considered rival contentions, though this court could have taken either of the views submitted before this court, that is of the petitioner, to proceed to appoint the arbitrator in terms of Section 11 of the Arbitration Conciliation Act. This court also the view expressed by the Council for the Railway Authorities that this court may await the decision of the larger bench, as the same has been referred as the decision since the correctness of the central organization has been doubted in the subsequent decision in Tantia, which has referred the matter to a larger bench. Perhaps it will be more. This court may not decide to proceed, to appoint the arbitrator under Section 11, but to await decision of the larger bench. Can we refer this also now?
It has come.
It has come now. It has been on hearing the Learned Council. After hearing the Learned Council, it has been brought to the notice of this court also that the Honorable Supreme Court, in a decision rendered in JSW Steel Limited versus Southwestern Railway and another, in SLP C number 9462 of 2022, decided on 16/8/2022, being seized of a similar issue about the decision rendered by the central organization, by the Honorable Supreme Central Organization, and also the earlier decisions in TRF Limited versus Energo Engineering and Perkins Eastman. This court, considering the fact that the matter was that a bench of 3 judges of the Supreme Court in Union of India versus MS Tantia Construction had already expressed prima facie its disagreement with the view taken in central organization, had requested the Honorable Chief Justice of India to refer to constitute a larger bench to look into the correctness of the decision central organization. The Honorable Supreme Court, in a said JSW Steel Limited, also took the view that since the correctness of the decision of the central organization based on which the appointment arbitrator was made and the matter has proceeded before the arbitrator was doubted by a subsequent bench of 3 bench, the matter be referred, the reference was again made for constitution of a larger bench, with the observation that since the issue has been reoccurring, it would be in the fitness of things that the question is resolved at an early date. First of, in view of the above order passed by the Honorable Supreme Court on 16/8/2022, it appears that the Honorable Supreme Court is seized of the matter, seized of the importance and urgency of the matter, and we expect and it will expect that the matter would be accordingly given expeditious consideration by the Honorable Supreme Court of India. Under the circumstances, we also the view that it will be appropriate for us also to await the decision of the larger bench so that the issues which have arisen in this petition can be amicably resolved in the light of the decision that may be rendered by the larger bench of this court. Under the circumstances, we direct that the matter be placed immediately after decision of the larger bench of the Honorable Supreme Court in this regard. So we will not dispose it of,
Very
we will
very
keep
well.
pending.
Your lordship will keep it pending.
So similarly, this order will be passed in Mr. Vishnu case also. Huh?
My lord,
Just one thing,
5 and 6, my lord, slightly different, my lord. I maybe allowed my lord to make my.
my lord, in
minutes, my
this,
lord,
my lord, the agreement date is 16/11/16 day. 2016 मिली को आसे जाए. It is
Earlier,
16/11/2016. Deeply obliged, my lord.
Yes, Mr. Goswami, what you are saying?
My lord, this 5 and 6, my lord, I am not relying on central organization, my lord, here in this case.
He is not relying on central.
No,
He's relying and sometimes he's saying he's not.
no, my lord. Because my lord,
So then we'll not at all refer to central, then we'll decide on the basis of non-central.
yeah, because my lord, central organization is those cases, my lord.
No, if you
But-
say then fine, then we'll hear Mr. Hussain.
Yes, my lord.
If you only say the central organization is say applicable, then as in the case of Mr. Goswami, then we'll await decision of the larger bench. But if you say the central, then we'll keep the central organization under seal cover. We'll not even
My lord,
look at it.
my lord,
I will not allow Mr. Hussain to open it
My
also.
lord, I'll only take 2 minutes, my lord. I'll produce one judgment, my lord, one para, my lord. And lordship will decide whether central organization or this judgment will follow, my lord.
Oh,
My
again you are Mr.
My lord,
Then you are saying that central organization is not applicable. This is applicable.
How can he take his
My-
full
my- my-
stand, my lord?
my lord, my submission is that, my lord, here in this case, my lord, I'll take only.
Let us see what he wants to say. Then we
Yes.
just try to understand.
My
We'll hear you,
yes,
Mr. Hussain.
My lord, kindly seek
What is the judgment?
section 21, my lord, before my lord coming to section 21 of arbitration act.
Okay, section 21. Yes, section 21.
Section when, my lord, arbitration commence, my lord. Unless otherwise agreed by the parties, the arbitral proceeding in respect of a particular dispute commence on the date on which a request for the dispute to be referred to arbitration is received by the respondent. And my lord, admittedly, in my lord 5 and 6, my lord, the request was given before the amendment, my lord. So arbitration starts before the amendment, my lord.
When the first or second one, say first or
Both.
second request?
Both, my lord.
Both.
Both, my lord.
Okay, first we will not consider, okay, because
My lord,
first,
first, my lord, I'll refer to first also, my lord. The date, my lord, the first, my lord, 5/4/9/2015, my lord.
see, when the amendment was made, Mr.
23/10/2015.
23/10/2015, the
15.
amendment, na?
My lord,
Amendment to section 12(5).
my lord.
Now, the second request was made when?
4/9/2015.
What is it? Page?
My lord. My page to my page.
Page?
My lord. This is. Just a minute, my lord. Page 157, my lord. Page 157, my lord. No. 157, my lord.
4/9/2000. No, this is the first time he wrote. This is the first time he wrote.
Yes.
And then, because then it could not be concluded within 1 year.
No, my lord. No, that I'll come later, my lord. This is section 11 notice, my lord. Section, that means, my lord, the arbitration starts from this date, my lord.
Correct, correct.
My lord, then, my lord, I will show, my lord, section 29, my lord.
Decision by making by arbitration unless otherwise agreed by the parties.
My lord.
Unless otherwise agreed.
By the parties in arbitral proceeding with more than one arbiter, any decision shall be made by majority. Notwithstanding authorized by so and so, some question of person may be there. So whatever this is how the decision is to be made. Fine.
My lord. Now, my lord, he has
Now he has
referred
referred to section
29, my lord. That 1 year, my lord.
1 year is section
29A.
29A. The award in matters other than international commission shall be made by arbitral within a period of 12 months.
1 year, my lord. When it comes, my lord. Kindly see, my lord, 2 below, my lord. Footnote, my lord, 2. By Act 3 of 2016 with effect from 23 to 2015. This is an amendment section, my lord, which came, my lord, in the year 2015, my lord.
No.
With effect from 23/10/2015, my lord. So it was not applicable.
Just a minute. 29A, na?
My lord.
Then inserted by 23/10/2015.
My lord.
Huh.
So, my lord, this is not applicable. Earlier, my lord, before the amendment, my lord, this embargo was not there, my lord.
23/10/2015. No, just a minute. But your arbitration comments according to you on arbitration comments,
4/9.
arbitration comments on
4/9/2015.
2015, when the notice for arbitration was issued.
My
Huh?
lord. My lord.
Now you are supposed to complete the arbitration
My lord.
under the old law when there was no.
My lord. Earlier, there is no.
There was no. Now this law comes into effect from 23/10/2015.
My lord.
Huh?
My lord.
Now the award in matters other than international shall be made arbitral within a period of from the date of completion of pleadings under section 4. Now this comes into operation. Now you mean to say that even if law has been amended,
My lord.
arbitration law has been amended, which came into effect on 23/10/2015.
My lord.
This amendment that is to prescribe the time of conclusion of the proceeding will not apply. Is it your case?
Yes.
And your plea is that even if assuming that the arbitration proceeding has started on 4/9/2015, because of the amendment.
My lord, there is a difference.
Yes.
Starting the arbitration proceeding and entering into the difference by the arbitrator are two different things.
What is that? Show us.
Section 21, my lord. Unless otherwise agreed. Either here, my lord, in our agreement, we agreed otherwise that the amended portion will be applicable. That is a different thing then. Unless otherwise agreed by the parties, the arbitral proceeding in respect of a particular dispute commence on the date on which a request of that dispute to be referred to arbitration is received by the respondent. Now here the question is, my lord, regarding the dispute, and now your lordship may come to section 29A. The award shall be made within a period of 12 months from the date of the arbitral tribunal enters upon the reference. Unless and until arbitrator is appointed, how can they enter into the reference? Appointment is made after amendment, my lord.
Section
29A, my lord.
The arbitral award in matters other than shall be made by the arbitral tribunal.
Yes.
Within a period of 12 months from the date of completion of pleadings.
No, my earlier lord. 1. The arbitrator award shall be made within a period of 12 months from the date the arbitral tribunal enters.
You are reading, just a minute, you are.
My lord, there is a other
amendment also, no?
No, my lord, there is an amendment in 2019, my lord. In
So-
my case, 2015 amendment is applicable. Some amendment is also made in section 29.
The award shall be made within a period of 12 months from the date of arbitral tribunal enters. upon
Enters.
them.
Unless and until arbiter is appointed, how can they enter into the reference? Starting the arbitration proceeding is different thing as per the section 21.
So according to 29A, as per 29A, which was applicable as on before
20
30/8/2019,
Yes,
after 23/10/2015,
it is applicable.
the award shall be made within a 12 months from the date of arbitral enters upon reference.
Reference. Now the arbitrator are appointed after the 23/10/2015. So naturally they enters into the reference
And
after.
arbitration was this 4/9/2015 is a request for arbitration.
Yes.
And
that appointment was
an arbitrator was appointed only when
when my lord, they on 5/1
5/1.
2016. 5/1 2016, after amendment came into force.
Therefore, according to then if that is so, then it shall be made within 5/1/2017.
Yes, within 1 year. But
Yes.
My lord, 21 says, my lord,
Mhm.
when arbitration proceeding starts, my lord, it starts from the day a request is made.
Unless otherwise agreed by the parties, the
So, my lord-
arbitral proceeding in respect of a particular dispute commenced
comments.
on the date on which a request for that dispute to be referred to arbitration is received by the respondent.
My lord, this is only for application of whether this amended act will apply or, my lord, this old act will apply. That this is regarding 2020, section 21. And my lord, 29 says, my lord, after, my lord, appointment of arbitrator, my lord, within what time this arbitrator proceeding should be concluded. So these are two different things. Man. My submission is that arbitration starts from the day when, my lord, the request is made, my lord. So, my lord, this amended act has no, my lord, used in my case, my lord, the old act will follow, my lord, in my case. And, my lord, I'll produce my lord, I'll place two judgments, my lord, of the honor.
Anyway, yes, you please.
Now, my lord, here in this case, the section 21, it says about the commencement of the arbitration proceeding in respect of dispute. And the section 29 it says about the entering upon the reference by the arbitrator. My lord. Now, my lord, whether oral submission is based on the document or something else. The pleading says, the conduct of the respondent says that they agreed for waiver, it is necessary for waiver of the condition mentioned in section 12(5). That is why they have given the format. Now, whether this argument sustain, when the document is saying something else, railway is accepting, the amendment is required, the waiver is required. Now, whether the submission will be made contrary to their own document, whether can they dispute their own document, the conduct of the parties clearly established that they are accepting about the amendment. Any oral argument, any oral submission will not be applicable, my lord, in this case, which is going against their own document. One cannot dispute their own document. Railway is admitting, my lord. And in this respect, my lord, arbitrators were appointed after the amendment came into force, my lord. And when the proceeding start, it also started after the amendment, my lord. There is a clear judgment, my lord, in this case. And the Honorable Supreme Court has recently dealt this point, my lord. When the proceeding, even appointment is made prior to the amendment, my lord. And if the proceeding of arbitration is started after the amendment, then the amendment provision will be applicable. And in this respect, my lord, I am the head. This is fully covering my case. My lord.
Yes.
Here, my lord, the heading itself is 12(5) read with 7 schedule of section 11, 12, 14, 15 arbitral tribunal comprising of the officers of the one of the parties ineligibility of to continue as such even when such arbitral tribunal is stood constituted prior to 23/10/2015, prior to the amendment of 2015 coming into force. Now I am coming to the
Therefore, if suppose arbitration has started
yes,
before this amendment,
yes,
consisting of member, employee of the railways.
yes,
Now, you mean to say that the moment amendment comes into play, that arbitration should stop
no,
because they are no more eligible?
yes, yes,
Then a new arbitration has to be constituted?
yes. Because in this case, my lord, this 3 judgments, here award has been challenged. Award which was not appointed because the appointment was not made as per the amended provision. That is why the honorable 3 judgments.
Anyway, that let us,
Yes,
because
yes.
that
So
in this Elora paper, what was the facts of the case?
Facts of the case,
In
the
Elora?
arbitrators were appointed who were the officers of the one of the parties
When?
prior to the amendment, my lord.
Let us see that para.
Yes. Para 4, my lord.
Appellant filed another suit seeking.
The appellant thereafter filed another suit seeking recovery of an amount of rupees so and so, bearing number so and so, before the civil court.
In
at
the
Bhopal.
said suit, the
In
respondent
the
preferred
suit, the
application
respondent
section of the
preferred
seeking a
application.
stay on the ground
Yes.
the examination and so and so. Rejected. And the honorable came allowed so and so the High Court referred arbitration. Huh? So the High Court referred arbitration.
Yes, yes,
2000, nah?
yes, 2000.
And then what happened?
I
Then
am
why the appointment of it? Then
The High Court referred the parties to arbitration by a stationary purchase committee comprised of the officers of the respondent. This is very
correct,
important.
because at that time there was no such provision in 2000.
Yes,
And then
but there was some stay order and then thereafter they started the proceeding.
then after that what happened?
Then Honorable Supreme Court said it is invalid.
Where is it?
Here, my lord.
Para 16.
Yes, my lord, 16.
Is observed above the evidence to consider officer of the respondent. Therefore, as per amendment, all of them have become ineligible to become arbiters and to arbiters. Section 12 amended based on amendment so. So that would affect, then
Yeah.
after non-abstaining clause on, it cannot be in the present case stationary 17. It cannot be disputed in the present case station committee complying officers are all ineligible and to continue with in view of session solution. Therefore, by operation law amending so arbitral station committee comprising of so as loss is mandated and as arbiter cannot be permitted to continue, therefore face has to be appointed. Yes, Mr. Goswami, 16 para 16, 17 solves our problem.
My lord,
Even if it was initiated.
my lord, lordship may kindly, my lord, I would like to refer my lord to 2000, my lord, judgment 2019.
No, but this is
3 SEC.
22.
My lord, lordship,
19.
kindly have a
Okay,
look, my lord.
19.
2019 3 SEC 282.
Yeah, have you given earlier? No.
My lord, once before my lord also I have given. my
Okay,
lord,
just
because I have
we'll
referred.
check. We'll check.
It is mine, right? It is mine, right? Rajasthan. 2019 3 SEC 282.
2019 3 SEC
282.
282. Huh? Yes, in that case,
In that case, my lord, para 23, my lord.
after the amendment to the Arbitration Conciliation Act in section prohibits employee in other
Prohibits the employee of one of the parties from being an arbitrator. In the present case, the agreement between the parties was entered into on 28/1/2000, and the arbitration proceeding commenced way back in 2009, and thus the respondent cannot invoke Section 12(5) of the Arbitration and Conciliation Amendment Act 2015. As per Section 26 of the Amended Act, the provision of Amendment Act 2015 shall not apply to arbitral proceeding commenced in accordance with the provision of Section 21 of the Principal Act before commencement of this act, unless the parties otherwise agree. So, my lord, it is there in the act itself, my lord. Next para, my lord. In BCCI versus Kochi Cricket Private Limited, this court held that the provisions of the Amendment Act 2015, with effect from 23/10/2015, cannot have retrospective operation in arbitral proceeding already commenced unless the parties otherwise agree. This word, my lord, commenced word has been used.
So,
my lord.
Mr. Hussain, there again appears to be certain contradiction in this.
Yes,
Apparent in
unless otherwise agreed. My agreement says we are agreed otherwise. If the moment any amendment is made, it will be applicable. When the agreement is there, there is this scope is there.
in the present case, there is nothing to say the parties have agreed to the provision new act shall apply in relation to arbitral. But in the agreement, it said the agreement is amended from time to time. What is that? What is that agreement?
GCC, my lord.
The agreement
But
itself
this
says-
is your also.
My lord, GCC has not been amended, my lord.
We are not on GCC. Agreement says,
What is the agreement was?
my lord, at page 72, my lord. How can one dispute his own agreement?
Page,
Page 72, my lord. This scope is there in the
page
amendment.
72.
Clause 64.7.
Subject to the provisions of Force Arbitration Clause Act and the rules and the instrument thereof shall apply arbitration proceeding under the clause.
The moment there is amendment, it will be applicable.
My lord, they are, my lord, contradictory, my lord. Contradictory, my lord, in the other case, my lord, they are saying that this amendment act cannot apply, my lord. My lord, we cannot make any modification, my lord. We have, after the amendment, my lord, we published the notification through which, my lord, we said that to accommodate this modification, my lord, this notification was published, and now in place of, my lord, serving officer, we are giving retired officer. That is not permissible, my lord, as per their own submission. Here, my lord, it is permissible, my lord. My agreement says that as per the agreement, my lord, already, my lord, the arbitration proceeding commenced, my lord. Arbitrator has been appointed, my lord, and now they are saying that no, since one of the officer has been transferred out, and we are supposed to substitute that officer, as per new amendment act, we cannot appoint. We are not talking about the amendment act, because since this arbitration proceeding commenced before this amendment act, and, my lord, there is a category provision, my lord, page, my lord, the previous page, my lord, page 71, my 10, page 71, my lord.
Yes.
Para 64(3)(a) Roman 2, my lord. Roman 3, my lord, last para, my lord, last para. If one or more arbitrators appointed as above refuse to act as arbitrator, withdraws from his office as arbitrator, or vacate their offices, or are unable or unwilling to perform his function as arbitrator for any reason whatsoever, or dies, or in the opinion of the general manager fails to act without undue delay, the general manager shall appoint new arbitrators to act in their place in the same manner in which the earlier arbitrators had been appointed. Such reconstituted tribunal may, as its discretion, proceed with the reference from the stage at which it was left by the previous act. Well, it was provided in the.
This is also an agreement.
Yes, well.
So according to him, there is a disagreement between 63(3)(a)(2) and the 64.7.
My lord,
Because if you follow 63(3)(a)(3),
My lord.
if one of the arbitrator is not able to function as arbitrator, either because whatever reason, transfer, then in his place the GM will appoint in terms of the earlier in the manner in which earlier arbitrator was appointed. This is also an agreement,
My
part
lord,
of the agreement.
my lord, agreement is there.
Ah,
Agreement cannot be amended unilaterally. Here the clause 64.7 says about the law.
Clause 64.7
Law
is not
says,
clear, my lord.
he is confusing.
My lord, the clause, my lord, I am referring to, my lord, it's clear, my lord. The 64.7, my lord, this is not clear, my lord.
By operation
What,
of
my
law,
lord?
this entire agreement is invalid. 64.3, 64.5, all are invalid. By operation of law. And the agreement says that if there is a law,
My lord,
change
there
in
is-
law, it will be applicable.
My lord, in my humble observation, there is no ambiguity, my lord. It is absolutely clear, my lord, how substitute arbitrator should be appointed, my lord.
I was dictating to you, Naki. Aage. No, earlier,
Yes, earlier, my lord.
huh? I was dictating to you.
Facts, yes, my lord. Facts have been recorded.
Huh? Dotto. Oh, Dotto, yeah, this one. Just ask Dotto whether he has typed or not. If he has typed, then let me.
And my lord, if the lordship, my lord, takes into consider this 64.7, my lord, then my lord, central organization will come, my lord. Then my lord, central organization.
Then again, my
Then
lord,
central organization.
again he is coming to the central agenda. That is why I
My lord,
submitted before
yes,
your
my
lordship.
lord, this is absolutely clear, my lord, how, but
When this part will be over, he will come to central organization. That is why I submitted
Well,
before your
either way,
lordship.
my
It's
lord.
better to wait.
either way, my lord, my submission is either way, my lord.
Then let us wait.
Yes.
But my lord, this, my lord, this judgment is absolutely clear, my lord. I can read, my lord, the whole judgment, my lord. Where,
My
my lord, the
judgment is
situation
clear.
same, my lord.
His judgment is not
And-
clear. My judgment is very much clear.
Then Likho, Mr. Hussain, learned counsel for the petitioner submits that. Then as per the terms of agreement as contained in clause 64.7, subject to the provisions which it has been provided at, subject to the provisions of the aforesaid arbitration, subject provisions of the Arbitration and the Conciliation Act 1996, the rules under the rules thereunder, comma, and any statutory modification thereof shall apply to the arbitration proceedings under this clause. Under the circumstances, once the amendment has been brought into the Arbitration Conciliation Act of 2015 by incorporating subsection 5 of the section 12, it will not be permissible anymore for the railway authorities to appoint an arbitrator who has been or is serving as an employee of the arbitrator. Under the circumstances, there is no other option but for this court to proceed appointment of an arbitrator under section 11 of the arbitration. On the other hand, Mr. Goswami submits that in view of the decision of the Honorable Supreme Court rendered in Central Organization this court in so
In Pradeep Binod, my lord. In Pradeep Binod, my lord, I am relying on Pradeep Binod, my lord, Union of India versus Pradeep Binod.
and also
And
and
the-
also in the decision of the Honorable Supreme Court in where is it?
My lord, 2019 3 SCC 282, Rajasthan Small Industries Corporation Limited,
Rajasthan so.
Ganesh Containers and Movers.
19 volume 3 SCC 282.
And my lord, 2020 2 SCC, page 464, Union of India versus Pradeep Binod Construction.
And also in terms of the decision in so. What is the name?
2020 2 SCC 464, Union of India versus Pradeep Binod Construction Company.
Thus, from the above, it is evident that that while the petitioner submits that this court can proceed to appoint an arbitrator under Section 11 of the Arbitration Conciliation Act, the same has been resisted by the Learned Counsel for the railway authorities, that the same that in view of the decision rendered by the Honorable Supreme Court above mentioned cases, the no application will lie for appointment under Section 11. Considering the above rival contentions,
And my lord,
and
one
since
more
the
thing,
matter has been brought to the notice of this court, that not only in Tantia case, but also in the recent decision of the Honorable Supreme Court in so-and-so, that JSW,
Yes, ma'am.
as the matter has been referred to a larger bench to decide the legality of the decision of the rendered by the Honorable Supreme Court in central organization so-and-so. We have the view, this court the view that it will be more appropriate to await the decision of the larger bench of the Supreme Court, as regards the efficacy of the decision of the Honorable Supreme Court in central organization. Accordingly, let the matter be listed. After disposal of the disposal of matter listed after decision by the larger bench is arrived at.
My lord,
This you can take this.
yes, 4, 5, 6, my lord.
4,
Same-
5, 6 same
yes.
order. So SL in
4, 5, my lord.
we 4, 5 also. The Lanaka, you're also there.
Yes, my lord,
My lord,
in 6, my.
2, 3, my lord, and 5 in IM.
The parties are the parties submitted in view
Sorry.
of the decision. It's not only that one. Parties submit in view of the decision of the Honorable
sorry, my
Supreme
lord.
Court.
In my case is 5, 6, 8, 9, and 10.
5, 6,
8, 9, and 10.
9, and 10. Even go. Isme you are there all naam, you are Chakraborty. huh?
Yes, they are there.
You write the sir, no problem. In the parties submit that it will be appropriate to await the decision of the larger bench of the Honorable Supreme Court after the decision in respect of the decision rendered by Honorable Supreme Court in central organization so and so, which has been questioned by another coordinate bench of the Honorable Supreme Court. Accordingly, let this matter be put up, listed after decision of the larger bench of the Honorable Supreme Court.
5, 6, 8, 9, 10.
5, 6,
8, 9,
8, 9, 10. Then
Eight,
next
nine.
other.
Timing 4.
Then I think 11 also will be there. I think similar. No?
I am for the 11 lordship.
I think similar order we have to pass. No, should
13 also, my lord.
11.
The petitioner is also here. May I call it?
11.
What is the petitioner to call? You are the for the petitioner.
I am for the.
He.
Item
Part-
7.
Item number 7.
11 MJ.
Same, my lord.
7.
Same, my lord.
Rightini also. We'll refer to larger, we'll await decision of the larger bench. Rightini also. In Rightini,
I'm 11, my lord.
just a minute. In item number 7, Jane also was the same case.
Yes, my lord. Yes,
Central.
right on, my lord.
Right, Ali.
Right on, my lord.
In 11 also, we'll await the decision of the larger
This
bench.
is something different, my lord. Already my senior argued in two times, my lord. And if your lordship permit, I will submit a written argument, my lord.
No, but in this case also, you're also relying on central. Mr. Goswami, in item number 11.
Item number 11.
No lordship.
Item number 11, I am not appearing, my lord.
I am appearing in
please
item
appear.
number 11
You
lordship.
are, in item number 11, you are relying on decision central organization,
No lordship. Actually, in item number 11, I am arguing that lordship, the matter may be liable to dismiss lordship. Because they not follow the general condition of contract lordship.
Okay, then on next day, we'll hear you. Okay. 10, 11, okay. Okay, 10 and 11, then we'll hear next week. 10 and 11 we'll hear. You come prepared, no problem. Okay, 10, 11, yes. On joint prayer, list the matter again, friends. Like this next week. Yes, next.
7 December.
Then 12, computer infrastructure.
My lord.
Yes, what is this matter about?
My lord, I had completed the work, my lord.
You have completed the work.
But the final bill as such has not been settled.
Yes, what is to be done?
We have filed the affidavit, my lord.
Ah.
The affidavit, my lord. we
And
have-
in what is the object? He wants an appointment arbitrator.
Yes, my lord.
They
And what is
dispute,
wrong with that?
There are disputes regarding a construction work. The work which he has done, my lord, we have made the payment. The rest, he wants the money, he have not done the work, my lord.
So that is for the arbitrator to decide.
my lord, that
Let
is
the
the
arbitrator decide.
There is no dispute, my lord, then. If he has not done the work, we have given
But
the
he says he has done the work.
I have a completion-
No.
I have a completion certificate, my lord.
complaint certificate is fake, my lord.
That will be decided by the arbitrator.
My lord.
And
No, but-
Mr. Lane counsel for the petitioner, House Lane counsel. Hey, parent, hey, file. Item number? 12, item number 12. Han, Mr. Mr. Pathak.
My lord.
B. Pathak, Lane counsel of the petitioner. Also, Mr.
Right,
Das.
SP das, my lord.
SP Das, standing counsel employment. The present petition has been filed seeking for a direction for appointment of an arbitrator under Article Section 11 of the Arbitration Conciliation Act for resolution of the dispute which has arisen between the parties. Petitioner submits that petitioner was
Look at the synopsis, my lord. Synopsis gives a detail.
was awarded a work for construction of work order.
ITI
Was
building.
awarded work for construction of administrative building,
My lord,
Yes, my
ITI building.
workshop building principal quarter grade so and so, page 18. White and in connection with which an agreement was entered between the petitioner and the respondent authorities on, what is the agreement? On 15 or
My lord.
19?
On 15th of February 2015.
Huh?
15 February 2015.
15 of
Annexure
February,
2.
15 February 2015. According to petitioner, they said the agreement contains an arbitration clause. Which is that?
Page 26, my lord.
Page?
26.
Which provides that? Page 26.
Of special conditions of contract.
Which provides for a resolution of a dispute or difference between the parties by way of arbitration. It has been submitted that the petitioner has upon a dispute submitted on failure of the petition respondent authorities to fully make full payment of the work executed by the petitioner. The petitioner and on payment, the petitioner demanded that the matter be resolved by arbitration by writing on 19/8/2021. On the other hand, it is the case of the respondent authorities that there is no dispute has arisen in which case all the entitled amount has been already released to the petitioner. To stop. As to whether then and it has been submitted that petitioner also has raised the bill on by making fabricated documents. Fabricated documents. Full stop. From the above, it appears that there is a dispute as to whether the petitioner is entitled to the amount claimed by him as final claim in view of the specific objections raised by the authorities from the which in our view from the above it is clearly evident that a dispute has arisen between the parties which in the opinion of this court ought to be resolved in terms of the agreement entered on 15th of February 2015, which contains for resolution of such dispute by arbitration. The page 26.
6, my lord.
Which clearly mentions that in case of dispute or difference between arising between employer and domestic contractor relating to any matter arising out of or connected with his agreement, such dispute or difference shall be settled in accordance with the Arbitration Conciliation Act 1996. the said clause also, which provides for, which provides for agreement within bracket clause 20, clause GC, clause 4 of the agreement, which contains arbitration in term, by referring to GCC clause 25(3). The said arbitration clause further provides that the arbitration clause shall concern 3 arbitrators, one each of the appointed by so and so, the arbitrators shall be chosen, so and so, so and so on. Now, here,
My lord, we suggested a name, my lord. They did not respond. So therefore, now, my lord, the matter is with the court. My lord.
now the court has to appoint
My
one.
lord. My lord.
3.
Not
Or only
necessarily 3. my lord.
Because the court is not bound by this
My lord.
agreement. Because in this regard, the petitioner had written to the authorities on 19/8/2021.
And 10/1/2021.
And also on 10/1/2021,
2021.
to which the authorities had not responded for constitution of the arbitral tribunal in terms of the agreement above. And the circuit have been submitted, the court may proceed to appoint an arbitrator to decide the dispute between the parties. Having heard the learned counsel for the party also on perusal matter record, this court view that the dispute has arisen. However, the parties failed to, however, the respondent failed to act upon the arbitration clause for appointment of the arbitral tribunal consists of 3 arbitrators mentioned under clause 25(3)(a), which is part of the agreement clause, which is part of the clause 4 of the agreement. And accordingly, this court would proceed to appoint. Whom do you want? Is it local?
My lord.
In Guwahati?
Guwahati, my lord.
Guwahati is Guwahati.
HK Sharma, Justice Sharma, my lord.
HK Sharma. Proceed to appoint Mr. Honorable Mr. Justice. HK means what?
HK Sharma, I think is there.
Full name? Hitesh Kumar.
Yes.
Hitesh Kumar. HK Sharma, Honorable Judge, who just
Yes,
retired.
My lord.
Yes,
His name is there in the panel.
Okay, we'll HK Sharma. To yes, the copy of this unless subject to his willingness and absence of any impediment is contemplated under section 12 of the Arbitration Conciliation Act. So copy of this order may be furnished learned arbitrator who shall proceed with arbitration in accordance with law. The next.
Item number 13.
Item number
13.
Durga.
Sometimes are filing rejoinder affidavit.
In 13.
Yes, ma'am.
Okay, Mr. Lane, please first. How long?
2 weeks.
2 weeks time to file. You are appearing here. You also hard also miss.
Are not
Are not
on behalf of SK Methi.
SK Medi. Yes. Yes.
21. 12.
Obliged to lodge.
Item number 14.
Okay, in this case, they are yet to file their response to.
14 will I pray for some more time.
How long?
2 weeks. my lord.
Further 2 weeks granted to the respondent to file affidavit. Yes, next.
14, 12. Item number 16 for orders.
Bhaskar Kanti. Yes. Yes, madam, you are there. Yes, madam. What is your case?
My lord, there was an agreement, my lord.
I am for respondent number 3 and 4.
What do you want?
Lordship.
Case should be dismissed.
No.
No. Should be allowed.
I have a talk with her. She doesn't have any objection regarding appointment.
Is it so? Very good. This should be always the approach. If you have already agreement to resolve amicably, there should be amicable settlement in the court also. And Mr.
A. Roy, my lord.
A. Roy Lane Council also means
P. Borwa.
P. Borwa. But you have everything in your mind because you have not wrote the record. Therefore, I assume that you have stored everything in your brain since you are not in document. Okay. File. The present petition is filed for appointment of the arbitrator under section 11 of the Arbitration Convention. The petitioner contends that having a dispute having arisen the petitioner sought for appointment of arbitrator in terms of the agreement. What is the agreement dated?
My lord, the agreement is, my lord,
Page.
my lord, page number 15, my lord.
Page number?
15, 15.
Not correct. This is the button. Why is the arbitration clause?
The clause is, my lord, the page number, my lord, 28.
28. In terms of clause
16.
16
Yes.
of the agreement dated 26 June 2018,
Yes.
which provides for resolution of all difference in a dispute by arbitration under the provisions of Arbitration Constitution 1996. Have been submitted after a dispute has arisen relating to what?
Appointment of arbitrator.
No.
Related to, my lord, the dissolution of the partnership firm, my lord.
Since a dispute has arisen regarding the resolution of partnership firm, the petitioner had written to the respondent for appointment arbitrator in terms of for resolution the dispute by arbitration. However, the respondent have not responded to the said proposal of the.
Whether they have deferred our proposal for appointment.
Okay. However, the respondent have deferred
Yes, ma'am.
to have not acted upon, have not
Accepted.
made any concrete steps taken, have not taken any concrete steps for reference to arbitrator, but merely deferred the same,
Yes.
compelling the petitioner to approach this court for appointment arbitrator. When this matter was taken up, it has been submitted by Ms.
P. Borua.
Borua, also that she has instruction that she has no objection to the appointment arbitrator. Under the circumstances, this court would, at least has not appointed, having a party on supervisory court, this court would proceed to appoint whom do you want? Any arbitrator?
Any arbitrator.
And
Fine.
whatever you,
My lord,
Roy,
C.R. Sharma is there. Justice
C.R.
C.R.
Sharma, okay.
My lord, one thing, my lord, the respondent number 1 and 2 has not appeared. All the services is complete, my lord. On the last occasion, you're.
Okay, likho pehle. Had Miss Barua, however, none appears for respondent number 1 and 2, though notice had been served upon them.
Yes, ma'am.
As indicated in the office note.
I will go.
Same, Baki same.
Item 17.
Abdul Kaif Ali, what is this? Review.
My lord, here review petition, my lord, but
This time may be allowed. My name was not reflected in the list and I have just received a copy, just 10 minutes.
Just 10 minutes before.
my lord,
And you require 2 days time to prepare.
This time only, madam.
my lord, he on 30, my lord, he is going to be retired. I'm very honestly submitting, my lord. And fact hearing is that, my lord, already similarly
When he is going to retire?
on 30, my lord.
30.
30.
30.
And
And
my lord,
today
fact-
what day?
It's 28.
28.
My lord, he
And
will
day
have to
after
submit,
tomorrow is 30.
my lord, he will have to submit this before his retirement. And my lord, fact hearing is that, my lord, the very simply, my lord, that similarly situated, my lord, other, my lord, colleagues.
Yes,
have-
madam, similarly situated person have been,
And my lord, that is, I'm annexing all the records.
correct, is
Everything-
it correct?
everything. Yes,
So same benefit may be
yes, my lord,
given.
everything identical, my lord, everything.
Okay, Likho, file what is done? File. Review, sir. And Mr.
BK Das, my lord.
I counsel for the petitioner. The present review petition has been filed seeking. What is the order?
That is on order is on, my lord, page 67, my lord.
67.
67.
Review of the order passed by this court on 16/11/2020. What is the review you want?
My lord,
What is the review you want?
review, my lord, the petitioner has been promoted, my lord, without servicing, my lord, any notice, my lord, they has been demoted thereafter, my lord, this honorable court has set aside this, my lord, reversion order, but has not been given any clarification, my lord, what they have did, my lord.
As a new order, this court, while disposing the said petition, passed the following order, para 4,
Para 4, my lord.
para 4 and para 5. It has been accordingly, it is a case of the petitioner that though this court did not
Para 4,
para 4.
my lord. It goes without saying that if the reversion order is set aside, the natural consequence will be the petitioner. That is, my lord, that has
will
been
follow.
modified.
So your reversion was set aside, no?
My lord, my lord.
Then consequently, the representative will be allowed to remain in the post.
Yes,
Then
my
what is the problem?
My lord,
With the
that observation has been, para number 4 has been, my lord, reviewed after, my lord, that is, my lord, that modified.
What is the modification you want of this order?
That, my lord, only that observation given in para number 4, my lord.
Why? Why it is not favorable to you? It is favorable to you. It goes
Yes, yes,
in-
my lord.
Okay.
That has been added subsequently after review, my lord. That is, this is the review petition order, my lord. Earlier, that clarification is not there, my lord, regarding that para 4, my lord. Subsequently, when they have filed a review petition, that observation in the para 4 has been made.
The natural consequence with the petition will have to remain post which the petitioner holding.
Yes,
So,
ma'am.
so what is wrong with that? So
Matlab,
what is wrong with this order?
Well, it's okay.
Then?
That's why I'm seeking, my lord, similarly order. In my earlier writ petition order, that
Oh, I show us that order, your petition.
my lord.
In the,
That is on,
Mr.
that is on
your-
page, my lord will file 55 page.
That's what, page 55.
55 and 56, my lord. Relevant
This is the
part
order you want to go in,
my lord, para 4.
Therefore, in view of this court pass the following order, page 56. While setting aside the order dated 5/1/2016,
2017, man.
2017, on the ground that it was in violation, it was issued on the ground it was issued in violation of principle of natural justice. However, this court did not pass any order about the consequential benefits which may be given to him. It has been submitted at the bar that in similarly situated cases, this court had observed that if the reversion order is set aside, the natural consequence will be the petitioner will be allowed to remain in the post which the petitioners are holding prior to issuance of reversion order, that is in grade 3 post. The said relevant portions of the order passed by this court in review petition 94/2020 in respect of Bimal Chandranath and others. This disposed of on 16/11/2020 as mentioned above. In this court has passed the following order in WPC review petition number 7, and it has been submitted that similar benefit may be also extended in the present case, so that after the setting aside of the impugn order dated 5/1/2017, he may be allowed to get the consequential benefits as given to the similar such person.
To remain in grade
That is to remain in the grade 3 post,
promotional post.
in the grade promotional post. So stop. Miss
MM Kotoki.
Even Kotoki very fairly submits that since the petitioner is similarly situated as the other persons in review petition 1994/2020, the state will now have no objection to grant similar benefit, that is to allow to remain in a post, that is a grade 3 post, which the petitioner was holding prior to the passing of the impugn order dated 5/1/2017, which was set aside by this court. And accordingly, after hearing the learned counsel for the parties, this court will view that the order passed by this court on 30/5/2019 in WPC number 8127 of 2020 is modified by observing that upon setting aside of the order dated 5 will also by modifying that to the effect that upon setting aside the impugn order dated 5/1/2017, the petitioner may be allowed to remain in the
Grade 3 promotional post.
grade 3 post which he was holding prior to the passing of said impugn order. That's all. The above modification, the present review petition stands allowed. Next.
For hearing item 18.
What is this, Hazarika? Oh, 115, 130. Where is the other council?
This is regarding appointment of driver of High Court.
Some other day. The
Time,
council.
timing for some other day.
My lord, item number 4 can be taken up of some other day, my lord.
Item number? Item number 10. Give a date. Yes, give a date.
7/12.
Four
কি করবো এটা?
दोनों का date
আপনার date টা লইলো।